February 3rd, 2022 to order and turn our meeting over to our zoning administrator, Joey Hargis.
Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of February 3rd, 2022. I'm Joey Hargis, Metro Zoning Administrator, and I'll be presenting the cases for review in today's public hearing. At this time, I would ask that anyone please silence or put their phones on vibrate so as not to disturb today's meetings. The board would appreciate that. The procedure will be to introduce the case record as the Codes Department has it, and we'll do so on the wall here by means of a PowerPoint presentation. I'll present any plans, photographs, maps of the properties involved in today's cases. The board has been presented with letters which were received prior to the hearing in support or opposition to the cases on today's agenda, as well as any correspondence from other Metro agencies. At the conclusion of my presentation, the applicants will come forward and present their case to the board along with any persons in support. Then after the applicants have spoken, the opposition will present their testimony to the board, and the applicant will have a period for rebuttal. In the board's rules, cases without opposition, the applicants have 5 minutes to present their case to the board. In cases with opposition, the applicants and opposition both have 10 minutes to present their cases to the board. That 10 minutes is in total, not per person. So if you have multiple speakers who wish to address this board today, please divide your time accordingly before you come up. Applicants, as discussed briefly a moment ago, you do have a period for rebuttal, so you'll want to save a portion of your 10 minutes. I will keep the time here at my desk on my iPhone, so I'll let you know both applicants and opposition when there's 5 minutes remaining and 3 minutes remaining in your testimony. All section numbers that we've referred to today come directly from the Metropolitan Zoning Code, which applies to the entire jurisdiction of Metro government. It became effective January 1st, 1998, and applies again to the entire jurisdiction. I'll introduce and make a part of the record the zoning code, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board come forward, have a seat at the table there in front of the board. Just to the right of the microphone is a button with a person on it. Push that button one time. Your microphone will become red like mine is here. Introduce yourself and your address and give your testimony to the board. It should be noted that it's found that anyone's presented false or misleading to the information to this board that may have affected this board's decision. Any approval can be revoked at a later date by means of a show cause hearing. I'll go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case in front of you. The board's vested with the power to act on these cases as outlined in Section 1740-180 of the Metro Code. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Currently, we have 5 members present. I'm expecting at a maximum 6 here, so you will need 4 of these members present before you to grant your application. In the event we have a vote that has less than 4 votes, let's say in this instance with 5 members present, a vote of 3-2, your case will stay on our agenda for the next 30 days. After that, within that next 30 days, at the next meeting, the board members who did not participate can become eligible by watching today's proceedings. The members who did participate are allowed to change their vote at the next public hearing. After that meeting, if your case has failed to achieve 4 affirmative votes, your case is deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, any appellant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period, but once that 60 days has elapsed, this board's decision is final. No further action can be taken. If you're an applicant and your case is approved today, it is necessary for you to obtain the permit for which you've applied. It should be noted you've got 2 years from today's date to obtain the permit for which you've applied, upon which your appeal case is tied. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the code, and affected properties were notified in compliance with the zoning code. Before I begin any preliminary announcements, the board does allow elected officials to address the board, should they wish to. Do we have any elected officials present with us today who'd wish to address the board? Mr. Chairman, I'm scanning the room. I don't see any with us. Okay. I do have a couple preliminary announcements before we get started with the consent agenda. Case 2021-143 on our agenda, Dwayne Cuthbertson at 1233 Lishy Avenue. They are putting the finishes touches on their alley reinstatement. It is likely this applicant will withdraw their case completely.
Okay, we'll just keep that on
I'll
until they
keep that
get.
deferred to the next meeting. And we received a request for case 2022-13. David Purser, the Nashville Chin Baptist Church, 5738 Cane Ridge Road, requests a deferral till February the 17th. Are there any parties present for case 13? Mr. Chairman, I
Does
see
any
none.
board members have an objection to that? Then that's fine.
Okay. With that, those two cases are deferred. We'll proceed with the consent agenda. The board does have a consent agenda, and prior to today's meeting, the chair reviews the cases in the application, and if in their opinion the applicant meets the criteria for the application they've requested and that they feel that testimony would not alter the material facts, they recommend the case to the remainder of the board. And I'll enter now those cases recommended by Chairman Taylor for consent agenda. And if you're here in opposition to the cases that I call, and only opposition, if you'll raise your hand, please, and make sure you've got my attention, and we will hear that case in its regular order. The first case recommended for consent agenda is case 2022-004, Parker Hawkins, appellant, Pep Music Square LLC, the property at 900 18th Avenue South, requesting a special exception to allow for additional height within the build-to zone in the RI district. Are there any parties present for case 4 in opposition to that case? Mr. Chairman, seeing none.
And that case is identical to one that we passed 2 years ago, and the conditions of that case are the same as they were when we passed it before, which were planning department's recommendations.
Yes, sir. And that case is one of many that you all have seen where the pandemic has interrupted their development plans. So as I talked about earlier, our approvals are good for 2 years. So I have a feeling we'll see more of these upcoming. And the second and final case recommended for the consent agenda with condition, case 2022-20, Rankin Design Works, PLLC, Scott and Ann Regal, owners of the property at 3507 Scarsdale. Are there any parties present on case 20 in opposition to this request? Okay. The applicants I see are present at the back room. This case is recommended for consent agenda with 2 conditions. The first of which, this carport is not to be enclosed, to remain open, nor shall it be heated or cooled for living purposes. Are you agreeable to those 2 conditions? Okay, Mr. Chairman, I see a nodding of the applicants back there. With those conditions, you've recommended to the other members that this case be placed on consent.
All right, there's a recommendation for the consent agenda. Any discussion or a second? I have a second. Any discussion? All in favor, say aye, raise your hand. Any opposed? That motion passes.
If you are here for cases 2022-004 on 18th Avenue and case 2022-20, your cases have been approved. Please follow up with the Codes Department beginning on Monday to discuss your permits.
Hey, Joey, on our packet, it shows 2022-019 being deferred to 217. Is that still on our docket, or is that being deferred?
You're not kicking stuff down the can.
Yeah,
Down the road, are you, sir?
if I were, it'd be 2 meetings.
Yeah, thank you, Mr. Newton. I missed that on my, I had an earlier print of that agenda. So also case 2022-19, Suburban Cowboys did an item A appeal regarding the properties at 3982 and 3978 Taylor Road. Have requested a deferral till February 17th, which will be our next meeting. With that, and our docket does say that case 13 is deferred to 213. That should be 217.
So were there
as well.
objections to that? Yeah, I had the earlier docket too, so I didn't see that, so that's fine. So if you're here for that case 20-22019, that case will be heard at the next meeting.
With that, we had had a request, and Mr. Chairman, I spoke with you briefly prior to the meeting, taking a case out of order in our sequence, and I'll call that case now. I've spoken to both the appellant, which we are going in front of, and they're agreeable to that as well. So our first case today that I'll call and put on the screen, as case 2022-017. Toon Intrican and White are the appellants. 1320 Fifth Avenue North LLC is the owner of the property at 1320 Fifth Avenue North. Sorry, bear with me one second. This is an item A appeal, appealing the zoning administrator's denial of building permit based upon MDHA's determination that hotel is not a permitted use within the Philip Jackson redevelopment district. Referred to the board under section 1708030, the appellant has alleged jurisdiction under section 1740, 180, item A. Okay, this case being an item A appeal, this is a special type of appeal this board hears, so the procedure is slightly different as far as sequence and timing. In this case, all parties will have 10 minutes to present their case to this board. We'll start first with myself and the Codes Administration as zoning administrator to talk through, introduce the case record, show photographs, give our position as to why we did not approve the permit. Second, behind me is the appellant, Mr. White. Will have 10 minutes to present his case, along with any time he would like to save for rebuttal, should he need it. And then finally, any parties, either way, for or against in the third group, that group gets 10 minutes in total. So if there are multiple speakers, they need to divide their time. Both myself and the third group do not get a rebuttal. So our chances to speak here are only if in our initial testimony or questions the board might have of anyone. In your rules, you're allowed to question any witness at any time in these proceedings. So with that, I'll get started with the photographs in the case and a recap here. The subject property is located on the east margin of Fifth Avenue North, just south of Taylor Street in Germantown area of town. Excuse me, aerial photographs of the subject property showing the buildings which have been constructed out here. And then views of the subject site from Fifth Avenue North. The next four photographs, these two and the following two views of properties either side on the same side, and then a view along Fifth Avenue to the west. Okay, and I'll leave this photograph here. The approximate timeline of events in this case in regards to a permit which was issued for multifamily construction of these two structures which you see here. Subsequent to the final completion of this permit, the applicants requested to convert the permit from multifamily to a hotel use. This property is currently zoned MUN under the zoning regulations, which do not permit hotel use. As part of the permit process, the inspectors came to make final inspections on the building, and were directed that they were inspecting a hotel, which really the permit was issued for multifamily. So in that, our office reached out. Ms. Emily Lamb is here should you have any questions of her. Reached out to MDHA, Parker Brown at MDHA, via phone to find out, does your Phillips Jackson redevelopment districts permit hotel uses? We were directed via that phone call that indeed they do, that the Phillips Jackson redevelopment district treats these types of developments as mixed use, and as so, they utilize the MUL zone district rather than the MUN to determine what uses are allowed. So pausing there just briefly, unlike the Historic Commission, and you've seen cases come here where Historic makes a recommendation to this board, the Historic Commission can govern setbacks, can alter setbacks within their district's height, appearance, but they cannot, they do not deal with land use. MDHA, that entity and the powers that they derive their powers from, they are granted zoning power. So they can regulate setbacks, heights, appearance, but they can also allow or disallow land uses that the zoning code does not otherwise allow. So in this case, as I mentioned, the aforementioned call.
And how does that process work? I mean, I know when you go to Metro Historic, they actually give you, a permit that, and they issue something. And so, and this is the first case that I can recall for, an appeal on an MDHA ruling. But what if, is it when they change the way a property is zoned or what you can build on it, do they just tell you over the phone, or do they have to write a letter, or do they have to give you a permit, or
Sure.
what constitutes them giving permission to do that?
No, happy to address that. They are added as a line item on our building permit process as a signatory to the permit. And so they'll sign off with approved or approved with conditions and make notes what their conditions are. The overall process, I apologize, I'm drawing a blank at the moment, whether they issue their own permit like Historic does, but they do have a design review committee that allows variances from their standards within these redevelopment districts. But the redevelopment districts are akin to something similar to an SP type zoning code. It's a way early precursor of SP, but it allows specific uses and specific setbacks and bulk regulations within their redevelopment districts that are apart and aside from the zoning code, which I enforce. So if they want to allow a use that the zoning code otherwise would not allow, they're permitted to do so. If they want to restrict a use that the zoning code would otherwise allow, they're allowed to do so.
And there's no question that they did tell applicant at one point, it's okay for hotel use, that's not disputed.
They directed, in the conversation Ms. Lamb had, and I reached out to MDHA as well, and left a message that MUL was what they were going to do. And then at the time the applicant came, finalized all the building permits, they were advised by our office, go ahead and get your final inspections as a multifamily, then come down and obtain a permit to convert from hotel.
And DHA had said that, we're okay with that.
Originally, yes, sir. And then that is not the case here. Upon the application of filing for the hotel conversion permit, they denied the request, saying that they were going to go with the base zoning and that hotel was not allowed. Now, other facts which are important and pertinent, the applicant constructed these buildings to comply with the hotel requirements under the Fire and Building Code. So there's not a codes issue from a building and fire code standard. These structures comply with the type of construction that's required for hotels.
Do you know if they meet other requirements for a hotel, like parking and any other issues that a hotel would require?
It's my understanding that to do. I don't know as far as the kiosk or the ability to take on-site reservations. Those are things that are going to be checked on the use permit conversion. So I don't know that we've fully gotten that far, but I believe they would be compliant looking at their site plan here. But that was something that we would check post this occurrence. We're not quite that far into it. But based upon that call that Ms. Lamb had, and subsequent, I think there was even an email from Parker saying that we would use MUL as our zoning designation. And then the subsequent denial of that ensued this appeal. One other bit of information. So we originally issued the permit as multifamily, got a final UNO. The applicant obtained short-term rental permits on each unit in this development. So there are active live permits for short-term rental in this. And I think a subsequent call came asking MDHA whether they permitted short-term rental uses in their redevelopment district, which that subsequent answer of yes, we treat it as mixed use, we would allow that to occur before we issued the short-term rental permit. So that's the hopefully not completely butchered timeline of events. I certainly offer Ms. Lamb or anyone, the applicant, when they come up, to correct my timeline if I'm somehow completely out of whack there. But that's the summation of our portion of that. So kind of recapping, our department cannot issue the permit to convert to hotel because MDHA will not sign off on this permit because they've deemed that this use is not permitted. And
the only permit they won't sign off on is the conversion to a hotel.
To a hotel, that's correct.
So the fact that, I mean, it's multi-family, the original permit that they applied for has been completed. And
yes, it has final
occupancy, and they meet whatever requirements they have to have for a multifamily dwelling. Okay.
Before I give up my time in 10 minutes, I know Ms. Lamb's here. Is there anything in the timeline that I might have? Okay. I think she's shaking her head no. So,
are there any questions for the zoning administrator or Ms. Lamb?
I have a couple of questions. So you're saying you couldn't issue the permit because MDH would not sign off on it?
That's correct. Yes, sir. Because it's in the redevelopment district and they do have land use control power in that, I'm prohibited from issuing this permit.
And that was the reason that you couldn't sign off?
That's correct.
Okay.
Yes, sir.
So
Unlike if this were a historic district and historic had said, hey, we don't want this use here, I'm issuing the permit. They don't have land use regulation
Right.
power, but MDHA does.
So it wasn't within your purview to be able to consider any kind of estoppel?
No, sir, that's not,
Okay.
no, sir. Not in that instance. That's,
And then if we were to say, or just to find that you erred, the zoning administrator erred and ruled for the plaintiff, what would they have to do to prove they had parking for a hotel? Or, I mean, that was an issue that I think the councilman raised and some other neighbors raised. And I'll ask you, we can ask the appellant too, but what would they have to do to?
we would need to review a site plan that shows compliance with the hotel provisions and the parking requirements for such. They do different from multifamily.
And so if we said that they were eligible to have this hotel, they would still have to go through the process of meeting all the requirements for your office?
From a zoning standpoint, they comply with setbacks, height, all that. It would just be to change the use. In any change of use, we look to see, is the new use complying with parking requirements or restrictions?
And then if they didn't have the parking requirements, they would have to
They'd
either
have to come
provide
here
them on
and seek a
site or
parking
find them
variance.
somewhere like
Yes, sir.
everybody else does?
Yes, sir.
Okay. Or come here and ask for
Or
a
come here and
variance.
ask for a variance.
Okay. Are there any other questions for the zoning administrator?
I appreciate your time. This is not, like I said, it's the first case you've heard. I think in 21 years of Metro, it's the first case I've had an appeal of MDHA's.
And then well, and I know from our past chair, David Ewing, that if it's on our docket, we assume that we have the authority, but just asking that, I guess that is the proper channel for the appeal. There's no MDHA appellate board, and
Yes, sir. It's my belief. It's properly before this board.
Okay.
This is the board with jurisdiction to.
all right, thank you. Anything else from the board? All right,
Mr.
then
Chairman,
we
that
will.
concludes my 10-minute portion. I'll turn it over to the appellants at this time.
All right, if the appellants would come forward and state your name and address and tell us why we'll say the zoning administrator, but I know that it comes to us through MDHA, but tell us why they were wrong in this case.
Mr. Chairman, members of the commission, my name is Tom White, 2 Network and White, 500 11th Avenue North. I'm here with Mark McGinley, who's the client's representative. I think the zoning administrator has spelled out all the facts. It's somewhat unusual, but the client started off on this site with the proposed apartment complex. People in this room are aware of the fact that despite what's going on in the economy, there's still a lack of hotel space in Nashville, especially in this part of town. The Chamber of Commerce says that repeatedly. If you talk to the planning department, they'll tell you the same thing. My client became aware of that as they were underway in this process and decided it's probably worthwhile looking at to see if that can be done. So they engaged my law partner, George Dean, who's certainly a well-recognized land use attorney. Mr. Dean came down, he met with Bill Herbert, the head of codes, explained exactly what we're talking about right here. And Bill told him, and Mr. Hargis can confirm, that with a redevelopment district, the codes department always defers to MDHA. That's what a whole development district's for. Hotel was not allowed under the base zoning, but that inquiry was made. On at least one occasion, I think two, telephonically, the codes department called MDHA and was unequivocally told that hotel was permitted. It's also in writing. Mr. Hargis has that, where the same individual, Parker Brown, confirmed that uses such as MUL were allowed. Hotel was clearly one of those. Based upon that, the client went through a very rigorous codes enforcement, transformation, et cetera. My clients here, they can testify about, they spent almost $500,000 because the requirements for a hotel versus multifamily. You can look at the structures, they're very high quality, been an asset, et cetera. So as they came through the process and spent this money, they came time to get the final UNO. And again, as they dealt with the fire marshal and the other departments, they said, well, you began this project as multifamily. And since you began as multifamily, let's just do the inspections as multifamily. And that's what they did. So they basically flipped it back to multifamily for inspection purposes. They cleared all the inspections. They did everything. And so the client then said, okay, we'd like to have the use and occupancy permit reflect that it is basically a hotel as opposed to multifamily, which is what we all agreed upon. Only on that occasion did MDHA look at it again. I have no idea why, came up with the reason that it wasn't allowed under this MDHA redevelopment district. Very, very perplexing, but there's absolutely no question about the assurances from MDHA orally twice, in writing once. The client relied on it, spent, as they'll testify, almost $500,000. With respect to the ultimate uses, here's what you have. It's proposed request that this department be directed to change the use permit from multifamily to hotel. That's the request. As Mr. Hargis says, you've got the authority to do it. I think the client complies with all the hotel requirements. I'll make this commitment. If it's approved, it can be conditioned upon us meeting all the hotel requirements. I think they're there. We're not trying to avoid anything. So that can be cleared with respect to all the issues that Mr. Hargis mentioned. But that's it. So you've got basically an operational facility down there. You've got short-term rentals on every one of these units. And the request is to make it hotel, which is one owner, far better control. And I suspicion that there may be some lack of understanding as to who may or may not be opposed. I think in general, people would prefer it not be multifamily with short-term rentals or a hotel, either one. But that's not the issue. The issue is, in fact, under these circumstances, it's equitable estoppel. I think the board's been supplied, as our office always does, a position paper, which was done, I think, on the 27th, but timely done and submitted. We covered all the facts that I've related here. There's no facts in dispute, no facts in dispute. The issue basically is one of equitable estoppel. The client has obtained all the appropriate permits, inspections, and spent the money in reliance on what was unequivocally told by MDHA to the codes department and to my client. As is often commented, basically MDHA has now said we're going to defer to the base zoning. We are now changing our mind. We're deferring that the base zoning controls, which doesn't allow hotels. And my comment to you is, if that's the case, why do you have a redevelopment district in the first place? Of course it's there to control the very things that Mr. Hargis mentioned. They've got zoning authority as opposed to historic and other entities. So my comment to you is, the argument makes no sense, because if you're going to revert to base zoning, number one, there's no reason for the redevelopment district. And number two, as Mr. Hargis can tell you, and you can ask him again, historically, this is exactly the way it's done. If there's a redevelopment district, codes picks up the phone, they call MDHA. The chairman asks, is there something formal, some procedure? There's not. It's been telephonic. It's controlled. The people know what's allowed. They check it. They respond. So it's not a protracted application, monies, et cetera. It's done telephonically. And here was done telephonically twice and in writing once. So I'd respectfully ask just a few minutes for my client to indicate what they did here. I'll ask for 2 minutes for rebuttal.
Thank you, sir.
Yeah, if you would just state your name and address, and then
Of course.
tell us.
Mark McGinley, my address is 6610 Fleetwood Drive, Nashville.
Mr. McGinley, before you begin, you got 5 minutes, 15 seconds just to give you
Thank
an
you.
idea.
I'll be brief. In May of 2020, when we got the kind of verbal approval to proceed with the hotel, we did a lot of things right off the jump. The big one, we installing a full 13-hour sprinkler system. There's no sprinkler requirement for the townhomes that we were building. So that entailed, putting in all the piping, all the sprinklers. It was destructive because the units were kind of already half built. And then adding some hotel stuff like the hand washing station is a hotel requirement, 2 dishwashers, et cetera. That was quite expensive. And then when we were almost finished in October of 2020, we actually got the permits at that point officially changed over from multifamily to hotel. That triggered a response from code saying, whoa, you guys haven't done the process here with the actual permits for R1. They brought us in. They had maybe several other things that they want us to add, some increased fire separation requirements. They want us to add fire panels and strobes and horns in all the units, and a few other things, fire riser rooms. We did all of that at expense of roughly $500,000 plus, 4 or 5 months of additional time of construction. So we relied on that earlier approval, and I'm hoping that you will grant this application.
How many units do you have?
13.
13, and then what, were there other, we had a case not too long ago, it was a camp, and we learned, we had a little bit of a lesson between what's a camp and what's a hotel, and I guess I'd like to know a little bit about, what the difference is between, what you have now and a hotel.
I mean, operationally, nothing.
And you don't have to have a lobby. I think that one of the things that the hotel, you were able to have day of reservations, and there were certain things like that, but.
Yes.
Or do you have to have walk-up, Joey, do you have to have walk-up ability for reservations with the hotel?
The code actually talks about, I'll just read. As we talked about at the beginning, read directly from the code itself. Hotel, I won't read the entire thing, but to your question, it requires both an A and a B. B part says accepts on-site reservations for accommodations. We have not, as technology has evolved, we've not necessarily demanded a human presence there. It can be a kiosk or some means of coming in, checking, oh, there's an opening, swipe my card, rent it on-site. They have to provide that ability on-site. It does not have to be.
Okay. But those are the types of conditions that you would meet if.
Yes, we have a kiosk, or we would be installing one, and then also on the parking front, when we had our permits were switched over from multifamily to hotel, the parking was approved then.
Yeah. And Mr. White, I have a question for you, and it goes, it seems like the bulk of the argument is the concept, and I'm not a lawyer, so you forgive my pronunciation, but the equitable estoppel, and which, we've addressed before in this board, but I don't remember us ever just saying, hey, this is a fair, this is something that we have the authority to do, even though we can recognize that there's some inequity, I think back on there are a couple of cases, one was just a week ago, last meeting or the week before, meeting before, where they had an email from code saying they didn't have to put in a sidewalk, but it wasn't really official, and then they had to put in a sidewalk, and that seemed unfair to the applicant, which we all agreed. And then there was one several years ago about a payday loan building that actually got built and was ready to go, but was not 1,000 feet from the nearest payday loan. And I think in that one, everybody, and had gone through the process, had everybody said it was fine until they tried to get their use and occupancy, and then it wasn't fine. And I think in that one, I remember us talking about, not having the authority to say, well, we screwed up, and therefore you should be able to do this, that was kind of the next level of the process. So can you address your thoughts on that?
Yes. Oftentimes, equitable estoppel is a doctrine that the lawyers on this board will know, but oftentimes it's difficult to apply to government. In this specific case, it's an interpretation call. And that's, as Mr. Hargis said, as a zoning administrator, the board's got the authority to make this decision. You didn't hear that in the other cases. In the other cases that you're talking about, it's the question, was something done in error, and it was black and white. The question here is basically, what was the information from MDHA, and MDHA's position now is that the base zoning ought to control and not their district. So in deference, now I want to say in the other matters, and I'm familiar with at least one of those, it was a black and white issue about what happened or didn't happen and the reliance on it. And was it just done incorrectly? And in this case, it's a question of, is the base zoning going to control, or is the redevelopment district going to control? That's a decision for this board, as Mr. Hargis said. But I want to be candid. Generally, equitable estoppel is difficult to apply against government and sometimes recognized difficult to apply. I don't think this is one of those cases, candidly.
So I guess if MDHA is, yeah, and sorry for, I in one of the, I think the next case, and then we hadn't gotten to that one, but in a motion to rehear, they quote me, and it's not very pretty. And so I recognized at the point when I read the quote, I thought, well, if the case is as confused as I sounded in that quote, So I told myself I probably wouldn't think out loud, but I'm doing it right now. But I guess I'm struggling too with if MDHA is the authority that is able to change the zoning, at what point are they, at what point do they give permission in a way that we should believe that the applicant can build? And at what point do they not have the right to change their mind anymore? I mean, it seems like that's kind of where we are, right?
Right. Yeah. I mean, I'll say this, it's $500,000 later, they don't have the right to change their mind. Secondly, if this board approves our request, as I urge you to do, basically MDHA can appeal that. They can look at it. They have a seat at the table. They need to make sure it does check off on all the hotel matters. I think MDHA is going to have to do a lot of thinking about the fact that twice orally and in writing they said this was okay. I mean, that's something they've just got to address. All I can say to you is that MDHA has the right to appeal this decision like anybody else does, and I would encourage them to if they think that they're correct.
Yeah, I mean, it seems without question there's a major process issue here.
At a minimum, $500,000 process problem.
I'm sorry, sir.
Sorry, yeah, if I may add, there's community support for this application. I spoke with Wendy Monday, who was on the Historic Germantown Neighborhood Association board when this project was permitted and while it was under construction. She lives next to the Germantown Inn, which is a hotel in Germantown, and she's very supportive of this application.
So you said that having the hotel, having the ability to call it a hotel versus what you're doing now would really not change your operations. Why is this? Tell me why you want the hotel. Why is that important to you? I know you spent a lot of money to get that, but why is having that designation important?
So we have the property leased to a group called Sonder, which is a international hotel / short-term rental operator. They just went publicly traded a couple of weeks ago. Big company. They prefer all of their operations to be hotels. They're all set up to run them like that. They have a facility that meets the hotel requirements here in Nashville, and they're more comfortable with that kind of regulatory framework. So to try to honor that request, we went forward with this application.
Okay.
Mr. Chairman, we've got 2 minutes for rebuttal. I'll take the last 30 seconds to close here, and that is that with respect to what's in front of you, in the other cases that you've mentioned, it was a clear black and white. At some point, an agency stepped forward, they appeared, and they said, no, we did that in error. Here's what we did. You don't have that here today. What you've got today is unequivocally what Mr. Hargis has presented. We think it's factually correct. So as I said, MDHA disagrees. They can appeal it. Don't think they will, but that's their prerogative. So we'll save 2 minutes for rebuttal and appreciate your courtesies.
Couldn't MDHA say, well, they made an error by saying that we would allow a hotel, and then no, it really is not?
Mr. Chairman, I did not speak to them. This all came through the codes department to us, where the codes department was incredibly apologetic and embarrassed and said, we really don't know how to tell you this, but we were now told that they defer to the base of zoning. Not that it's not allowed in the redevelopment district, but we basically go to the base zoning. And as I said, the problem there is that if you're going to always revert to the base zoning, there's no point in having a redevelopment district. I mean, there's no reason for it. It doesn't make any sense.
Okay. Any questions at this point?
Yeah, just so that I'm following the whole thing, they applied for one purpose, discovered that they can have a project that develops probably more profitable. So they change midstream, then they start going back and trying to correct stuff after they've changed.
No, I want to clarify this. Before they ever decided to make the change, George Dean came down here to the codes department before they took the first step. They hired a good land use lawyer to come down here and say, looks to us like a hotel is probably allowed. What do we need to do? And they were specifically told, number one, we, the codes department, always defer to MDHA because it's an MDHA development district, and we get on the phone and ask them. The client then waited for the response. Within a short time later, they were told, we made the contact. Here's the individual. who said hotels are allowed. They then talked to Mr. Dean again, told him that. Only then did the client go through the process asking, do we need anything further from MDHA? The answer was no, it's always done telephonically. They then spent this $500,000, but they didn't do one thing, Mr. Lawless, until they were down here at the codes department doing it exactly the way I would think business people ought to.
And the next writing is basically here. The writing, when all the problems broke out.
When all the problems developed, I mean, by that time, the client had spent, as he said, like 4 or 5 months, close to $500,000 doing things that I think this group could identify with. And basically, we're ready to have the use permit issued for a hotel. And again, one thing I'll say unequivocally, if there's anything my client didn't do in compliance with directions from Metro Codes, I'd like to hear it because it doesn't exist. I mean, they hired a good lawyer, they came down here, they tried to do it right. And they were just stunned, frankly, when it happened at the end of the day. And as the chairman said, there was a reason, and you nailed it. Financially, sure. They felt more viable as a hotel. There's nothing to be faulted for there. That's what business people do. But they did it correctly. They didn't do it after the fact and then ask for some forgiveness.
Thank you, Mr. White.
Any other questions at this point? All right, you save your time, remaining time for rebuttal. And at this point, anyone in the public that's here can speak. There's 10 minutes total. And it's a little bit tricky with the item A to say what you're for or against. But if you are against it being a hotel, you can say I'm against it being a hotel. If you're for it being a hotel, you can say I'm for it being a hotel. And we'll know from that what side of the yeah, no, and again, it's not a democracy here. We're not voting from the audience, but it'll let it's a democracy on this side. We get to vote, but it's not about who shows up to say.
Yeah, Mr. Chairman, a couple things just for housekeeping purposes. In the next group coming up, as a total, this next speaking group has 10 minutes. Again, work out your time. Who's coming? I'll keep time here. I'm happy to turn my phone around to face you so you can see how much time you've got. I do, for the record's purposes, want to clarify one statement I made in my portion. In looking through the phone conversation about the hotel occurred first. The email that we have, clarifying, that we reached out to MDHA regarding the hotel by phone. And it was later substantiated, that conversation, when Emily emailed Parker about, hey, are you guys okay with short-term rental use, before we turned out the use. And Parker's email says, our plan is silent on short-term rental permits. This property falls within what we call mixed use, which allows anything that MUL allows. He's distinguishing MUL from MUN. So I offer that as substantiation to the statement that they've told us that, oh yeah, hotels, are permitted as MUN because we treat it, this area like mixed use. So I hope that clarifies at least what I was saying. I didn't want there to be, oh yeah, we called them twice about the hotel and then got a subsequent email about the hotel. The timing in that's a little bit different than I may have came out in my portion. So I want to be sure. And like I said, I reached out to Parker, didn't have a conversation with him, but left a message. We're, as zoning administrator, I'm fine with you all permitting uses or disallowing uses that the base zoning permits. Under the zoning.
All right, so. Yeah, that's fine. As long as, you can fill the table however you'd like, and that'd be fine. So if you would press the button, make sure the red light's on.
Can you hear me?
Yes.
All right, my name's Emily Forsyth. I live on 1314 7th Avenue North, so just a few blocks away. And I'm nervous, so I'm just going to read what I wrote. So I've lived in the community, and I've watched these units getting built and getting filled with hotel people. There's not community support for this, so no one in this community wants it. I've seen the damage that these hotel units are doing. It's very transient and careless people renting these. Trash has accumulated, parking's a nightmare, drunk people are wandering the streets. Germantown is not Broadway. These units are still operating as a hotel, even though the developer just admitted that they knew what needs to be done to convert to a hotel, but they're not doing it. There's no kiosk, there's no fire lane, there's no ADA, total disregard for the rules. The other thing I want to call out is how sneaky and manipulative this developer is. The developer got greedy halfway through the process and thought they could get more money without following the correct permitting process. What I am worried about is by allowing this developer to manipulate the system, this creates a precedent that has the potential to destroy the wonderful community that is Germantown.
My name is Evan Gracie. I'm a construction professional. I also reside at 1314 7th Avenue North. Understanding the processes in construction allows me to understand maybe how they got to where they are timeline-wise. However, I would love to see permit amendments, when those were filed, in what process, and what all permit and red line amendments were sent into the community. That could open up Pandora's box and tell us if what is being said is in fact true. I'd also like to inquire as to the domicile that is located next to the Germantown Inn. Again, being a resident, there is no domicile located directly next to the Germantown Inn. There's a rental property, there is a church, and then there is an event space directly across the street from Monell's, another commercial space. This also leading on to the grounds of precedent, being next to the machine shop. This is a great area that it could be cleared for a hotel space, and then in the future, this hotel space already being allowed can build up to several levels within Germantown, outside of the historic district, could go over 5 stories. It could come in and, again, destroy the community. Wavering back on what the plaintiff said, living in Franklin by his address that he stated, he chose to live in a community that was not permitted for hotels to be within the subdivisions there. And we choose to live in Germantown for that same reason. Thank you.
Miss, before you begin, you pause a group of 750 remaining. Break you. I think I messed you up, David.
It's flash. Okay, they're all messed up.
Yeah, hang on one second. Do we need to get,
Yeah, let's get 1 second.
It's time.
no, it's still blinking.
Take its time. The clock. Hey, listen.
Hang
Looks
on,
like it's working a little
no worries.
bit.
Hang on one moment, man. Try.
All right. All right, yeah, ma'am, you can. It's taken off the clock.
It's still flashing.
Hang on.
Okay. Sonia Link, address 1308 6th Avenue. As far as me personally and most of the people I've spoken to in the neighborhood, we prefer for things to stay what's allowed in the base zoning. That's how the neighborhood determines what's allowed on the lots, determined to the land use for each base zoning. If the developer wanted this to be a hotel, they should have applied for a rezone to MUL. The neighborhood would know that. We would be able to put our input into the Metropolitan department as if we support or oppose that. But having something zoned MUN and now trying to change it to something that's not allowed in that base zoning, to me is the incorrect procedure, and we should not allow it. There's a big difference between this is currently short-term rental. Well, short-term rental, you have to get a permit every year. There's restrictions and there's guidelines. If they go against the restrictions of too much noise or whatever, if they get 3 strikes, then their permit can be revoked. With a hotel, we lose all that protection. Yes, we prefer for it to be residential, We prefer for it to not to be short-term rental because, as the other neighbor said, it causes a lot of trash and noise and things that we prefer not to have into the neighborhood. But at least with short-term rental, it is a permitted process, and there is possibility, if they don't go by the guidelines, that permit cannot be reissued. Whereas with a hotel, it's a hotel, and we lose a lot of our input for that.
All right, thank you. Yes, sir.
See if it works. Oh, it does. My name is Ron Hogan. I live at 1227 Fifth Avenue North, about 3/4 of a block from the STRs right now. I've been dealing with, with Bill Herbert off and on for about 3 years now, talking with him about this complex. Our main concern was when we I'm also the president of the Historic Germantown Neighborhood Association. The firm came before us to make a presentation about what they were presenting, and they presented to us that it was going to be 13 single-family townhomes. We specifically asked them if it was going to be short-term rentals. They said no. They said no. When they filed the plans and went for the started building, we were looking at the floor plans, and you started looking, you going, nobody possibly could buy a home here because there are bedrooms, one single family room, no laundry rooms, no storage rooms. Parking was the big issue. They have 16 parking spaces, maybe 17, I'm not sure. Hotels would have one per sleeping area. Sleeping room, not sleeping area. I show you conversations back from 2 years with Mr. Herbert about that. If they had applied for a hotel, nobody told us about it. MDHA didn't say anything. Mr. Herbert never said anything about it. And if they had done this right off the bat, like we understand, why weren't we told? I don't know if you've heard the term condo-tel. This is what this is going to be. It's 13 units that this is their exit plan, at least as we can see. Right now, they could continue this on. They're making the same amount of money as they would be if it's a hotel. I don't understand what the difference would be. But their exit plan is they make a hotel, they sell these as 13 individual condos. Those people then have a homeowners association that deal with the management firm. They split the terms there. This company takes their profits and leaves. And we're then dealt with 13 different homeowners or potential homeowners. Is basically like a timeshare, but short-term rental. They also get out of the short-term rental issue, so we don't have to deal with that. Anyway, that's our concerns. And frankly, they couldn't. We don't see how they could go from MUN to MUL without any type of other than MDHA saying, "Oh yeah, you can do that."
Right. Sir, I think Ms. Davis has a question for you.
I do. Do you recall when that meeting happened with the neighborhood association?
I'm sorry?
Do you recall when that meeting occurred with the neighborhood association?
It was
The
before.
neighborhood association. Oh.
When the developer presented the plan?
2.5 years ago, 2 years ago.
Were there any other meetings after that where they came and presented?
Well, when we saw the plans, we contacted Mr. McDonald, the other partner in the firm, and we've got several emails with him asking him to come back and talk to us about this, and they refused to talk to us.
Okay, thank you.
I will say that one other thing, the developer or attorneys indicated there was community support for this and mentioned one person. There's not community support for this, so.
Great, thank you.
Thank you.
Anybody else like to speak? Come forward, please.
Those remaining wishing to speak, you've got 3 minutes and 45 seconds, so whomever would like to come on up. If it's just you, sir, and you miss, you guys be sure to divide your remaining time.
My name is Drew Cares, and I live across the street, 1325. I've spoken to I'm going to go fast. Sorry. 6 of my neighbors were all against it. We're surrounded by 4 liquor establishments, commercial establishments on the west and on the north, occasional gun, it's just wholly inappropriate. And then something I wasn't going to discuss, but they have units. I have a unit, I have pictures of the unit online right now at $1,000 a night. I'm wholly unimpressed by this $500,000. They've got expensive attorneys. I looked up the land value is $10 million. They can absorb whatever is necessary to do what they said in the beginning and make this right for the neighborhood. Thank you very much.
All right, ma'am. Ma'am, just if you would press the button and just make sure the red light's on, and that way it'll record for you. All right.
Hello, I'm Ellen Mrazek, 1313, right across the street, 5th Avenue North. The question the gentleman asked, why do you need the hotel designation instead of the STR? I don't think they gave a very clear answer. Because Sonder prefers it, that's it. I don't understand that. I think there's more to the story that they want the hotel designation, and I think they should have to explain why the STR isn't appropriate. I don't understand it. All this verbal stuff also, I don't understand. Before you dig, you get a permit. They had a multifamily permit issued. They started the project. A year and a half later, they changed their mind to make it an STR. They got the STR permit. Now they're saying verbally they got a hotel permit, but it's not in writing and it's not printed online. I don't really think they would go through all this trouble without getting an actual permit. And they're also, I think it's the $500,000 they spent to do sprinklers and hand washing. I think that was probably to change it from the multifamily homes to the STR. And they're conflating it with the hotel. So I have a real question about the hotel. It doesn't make any sense to me. It's zoned MUN. You can't change it to MUL for no reason. Germantown Inn is a B&B boutique hotel. It's not a hotel in the sense of hotel. There are no other hotels in Germantown. Obviously, they aren't permitted. Phillips Jackson was a redevelopment agreement that started it was established in 1993 to eliminate blight. We don't really need to eliminate blight on 5th Avenue, so I don't think it's appropriate to look to that and allow any development possible because of Phillips Jackson. So I would really like to know why they need it to be a hotel rather than an STR. And I would add, they've done no outreach, no information to neighbors. I live across the street, no outreach to the council person. We saw the sandwich board go up. We saw this letter. And we were completely confused about why they needed a hotel designation because it's already operating as an STR. And we don't like STRs anyway. They don't contribute to the neighborhood as far as building community. So, thank you.
All right, thank you. Anybody else in the little bit of time?
Got about 45 seconds.
Sir, if you you're welcome to speak, but if you do, you got to come up and state your name again.
Yes, pardon. Evan Gracie, 1314 7th Avenue North. Just in response to the statement why for a hotel, that would nearly double the property value on this and make the sale for their future considerably more valuable, 500,000 gone, if this is zoned as hotel use in the area. Additionally, for the temporary use permits or single-use rentals, I do believe there is a motion for that to change in the next 18 months, and those will be eliminated and need to be reevaluated.
Thank you. All right, so we will have the applicant back and for rebuttal.
Mr. Chairman, first I want to clarify from my client's perspective who's here, the client never made any representation with respect to anything on the property other than they intended initially to do it as multifamily. That was it. I heard a comment made by somebody that there was a comment made at some meeting or presentation. It was not my clients. They're here. They can be asked that. I don't know who else was involved or who heard that from, but it was not my client. Secondly, you just heard from the last gentleman that came up, and I thought it was somewhat ironic, the hotel's going to increase property values out there. It's clear nobody likes short-term rentals. They may not like this proposal either. But at the end of the day, the hotel, as far as property values, is what's going to be the best thing for the neighborhood as far as values, and be the best thing for Metro government with respect to taxes that may be used out here. But with respect to how the process came about, all I can say is that this was not a rezoning. This board's familiar with rezonings where you come in, you make an application, you have neighborhood meetings, you have different things, planning commission, et cetera. This was not any rezoning. It was zoned, period. And the client did, in my opinion, the only responsible thing, and they sent a responsible lawyer in here to ask, how do you do this? And then they spent the 5 months, they spent the $500,000. So there was no subterfuge here of any sort whatsoever. This board's got the authority to do it, and I'm commenting in light of the twice oral and once in writing confirmation that my client relied on in good faith. I asked the board to basically allow the use permit to reflect the hotel. Again, if there's an appeal, whether it's the neighbors here or it's MDHA, it can be done. But I think that's equitably what happened. There's a lot of professionals sitting on this board today. If this were your client and they came down here and did what we're talking about here, I think you'd feel pretty strongly that they should be allowed to do what they were told they could do, especially after spending $500,000, which hasn't been disputed here, and it's logically what they would have to do to make it adaptive. So I appreciate your courtesies. I think it's a strong, equitable, estoppel case, and the client acted in good faith. Nobody's ever said anything that they did not. Thank you.
But how is it not a rezoning? Isn't that the only reason that we're here is because MDHA has the ability to determine what zoning is permitted or not?
No, it's clearly not a rezoning case. A rezoning case is where it's zoned MUN, you want to change it to an SP or an MUL or something else. That's a rezoning case.
But they wouldn't even have to go to, and would they have to go to MDHA if they complied with MUN?
No. I mean,
So they had to go to MDHA to get away from the base zoning.
That's correct. And that's what they came.
And so MDHA, essentially through MDHA's authority, rezoned it and then maybe didn't.
But
I mean,
my
that's where I'm
comment,
getting
Mr.
to.
Chairman, I don't think it's a rezoning because frankly, you had two overlying districts. One was the base zone district, which was MUN.
Right.
You then had the MDHA redevelopment district on top of it. Nobody changed either one of those. What they were, nobody's changed those. It was an interpretation call. That's why it's an item A case in front of the board. There was an interpretation call as to what was to be allowed, and MDHA originally said, we think it's clearly allowed under our MDHA redevelopment district as a hotel, as Mr. Hargis read, and then they came back 4 or 5 months later and said, no, we think the base is zoning control. So it's not a zone change. I don't think anybody's going to disagree with that. There are two zoning categories. One is the base zoning, the other was the MDHA redevelopment district.
Okay. And, I'm sorry, Ross. No, you're good.
So MDAH can change the land use, but it's not rezoning because that's a whole different process, but they have the authority to change the land use.
Much like under MUN, there's different zoning categories. Do you or don't you meet one of the MUNs? In this case, do you or don't you meet the redevelopment district allowances? And as Mr. Parker said, if anything allowed under MUL is okay, which was one of those was a hotel. So it's not a rezoning. It's what's allowed under those categories, frankly, sir.
But it allows them to change the use.
Yes.
Okay. And your client followed the process that was in place. It's not a rezoning process because it's more informal than that, really. But you followed. There was no other. You followed whatever process was in place to get the permission of MDAH to have a different land use.
Correct. That's exactly what we did in good faith, and nobody said we didn't.
Okay, I was about to ask you that. Did MDAH ever say we're not going to allow this because we don't think you follow the proper procedures within MDAH?
No, they never claimed anything. Of course, it came through the codes department, but we never heard anything that we did anything incorrectly at all. They basically said, looking at this a little further, not that it's not allowed under MDHA, but more importantly, we think we should defer to the base zoning, which they knew from the front end didn't allow a hotel. So it was just 180 degrees difference in saying we're going to go with the base zoning here, which originally they said, no, it's historically, as Mr. Hargis will say, the codes department defers to MDHA. There's no point in having MDHA if you're going to run with just the base zoning. But that's what MDHA originally did, and then came back and said, oops, we changed our mind. We're going to ignore the fact that we've got authority here. We're going to go with the base zoning, which is something I'll have to answer for someday, I guess. But that's how it happened. I don't think I keep saying this, there's no factual dispute here about anything. It's basically a question of how it happened, and if in good faith there's a good equitable estoppel argument here, and I think there is.
And then, I'm sorry, Christine, go ahead.
Sure. I've always known the MDHA Design Review Committee as a committee that enforces regulations that are deal with materials, perhaps, or height, or. So did you go to that actual committee and discuss this with them, or was it just the staff member?
In fairness, it was my law partner, George Dean. I don't think that we went to any MDHA process. And again, Mr. Hargis is here. They never do that. It's basically a call from the codes department to MDHA to the people that have been there, like Parker, that have been there for decades. That's what they do. There's no formal process. You don't submit anything. And I know you folks meet over there periodically on the design review committee. That's not what takes place. It's a contact from this department to that department saying, we defer to you, and you get an answer. That's what took place. So no, there was no process to my knowledge other than Mr. Dean coming down here to visit with Mr. Herbert and the people at Codes. That's all that I know.
Maybe I could just clarify one thing. We did, when we went through our building permit process initially, we did go through the MDHA design review process. But that was focused solely on massing and aesthetics. It had nothing to do whatsoever with the use. That was a totally separate discussion.
Thank you for clarifying.
No problem.
Last thing, I did just want to clarify, Mr. Chairman, I heard someone at the mic indicated that, somebody, ownership or somebody basically came to a meeting and said it was such and such. I've clarified my clients here. That was not my clients. I don't know who else looked at the property, who did what, but that was not us.
So did you have any community meetings with anybody in the neighborhood about this project?
When we first conceptualized the project, we hired our architect, Nick Dryden, who had done a number of projects in Germantown. He knows all the folks over there very well. So we asked him to go meet with them voluntarily to share the design that we had come up with for the building. It's in the historic part of the MDHA, in the Germantown overlay. So it's very strict as to what type of materials and windows and such. So we sent him to go and have a design-focused discussion with the Germantown community. And he was concerned about, that they would have questions on use, which is not part of the MDHA design review purview. And we just said, look, we're not sure what we're going to do with it yet. We want to build it. We want to maybe do it as townhomes. We're not sure which way we're going to go. So just kind of be silent on that and focus on the design, which he told us is what he did. But I never attended any meetings, and neither did my partner.
And there's no question we complied with all design requirements. Nobody's raised that either.
Any other questions? All right. Thank you very much.
Thank you for your time today.
Thank you.
We will close the public hearing.
I'll
Ms.
start
Davis.
us off. Since
You've been dying over there.
No, I haven't. So I think this is a really hard case, right? And so I think what I'm struggling with, and so I'm interested in listening to the expertise of this body, is that it's no doubt that the applicant went through a process that exists, and that process is owned by MDHA, and that codes defers to MDHA in that process. And Mr. White said that they deferred, that typically how this goes is that we would defer to MDHA. I don't know why we wouldn't defer to them here. It seems like, I just said, I don't know why Mr. White said in his rebuttal that typically with this type of project, MDHA, like codes will defer. We'll just defer to MDHA. The codes department will defer to them because of that overlay. And in this case, I don't know why we wouldn't just defer to them. Like, I'm still confused why this is something that we would fix. Like, I understand the problem, but we didn't create the problem. So I'm a little uncomfortable sometimes fixing problems that the codes department didn't create. So Mr. White said typically codes defers to MDHA, and I think from what I've heard so far, I think we should continue to do that because the impact of us trying to fix this problem is essentially a change in zoning. Now, I know that it's not a real change in zoning, but for people who live in this neighborhood and this operating the way that it does, it would feel like a change in zoning. And so I'm still listening, but that's sort of my first thought.
Mr. Hargis, can you please clarify what is the actual process to I mean, I know we've kind of been alluded to by Mr. White and by, I think you alluded to it earlier, but what is the official process for a change in land use between what the base zoning is and what MDHA would allow?
Sure. The process for building permit review, when building permit applications are made in MDHA districts, we track them on the building permit as a sign-off to obtain the permit. So the facts in this case is we issued the permit as multifamily. So they approved it, signed off on the permit, and issued it. And that's where the conversation came up. Look, they're wanting to change from hotel from multifamily, in which the phone call, we made asking about, let me back up. The original phone call and email we received, which I read earlier, was about they want to do short-term rental in these. And the answer was use MUL. That phone call also occurred on the, hey, they want to change from multifamily to hotel. So as part of the permitting process, we will track MDHA again on that. And that's in the conversations that Mr. White talked about. MDHA has made clear they're going with base zoning in this instance. So that's what ensued this appeal. It's not, that's the formal process, and we track them. We do make calls to MDHA, when people are inquiring, what can I use my property for? I don't want to type a building permit and go through all the reviews and then find out, we do make calls over to that department to find out, is this something you all would permit before we get started with this? But I'm not saying that occurred in this instance on the conversion of hotel, but that's the typical process of it. They're tracked on the building permit like water and grading and fire marshal, all those types of sign-offs that you get for building permits.
Okay. And maybe this is more for my own edification. The short-term rental use of this property, is that set to sunset or expire in the current, are either the MUN or the MUL-based zonings over the next few years as of current legislation? Do you know?
No, sir.
Okay.
No, sir. There's not been any legislation filed with the council to take it out of mixed use. There was recent filings in RM zones, but not in mixed use.
That's what I wanted to clarify. Thank you.
Mm-hmm.
Other thoughts? I tend to, I'm struggling with the same, maybe not saying it exactly the same way as Ms. Davis, but you say it much better and more concisely than I do. I've got a whole lot of thoughts in my head that kind of get to the two sentences that you said it. And on one hand, though, I do understand, it's the same issue as I think that we've heard before, where people have come and said, I was told I could do this. There's something about it that doesn't seem, fair. And yet at the same time, I know because it's on our docket, we have the authority to hear the case. But being the only case that, Mr. Hargis said in his 20-some-odd years experience, and certainly in my 10, I just don't ever remember a case that has us going against him, ruling against MDHA and their ability to, and we don't have them present. We don't know if it was, if the first, we have an email that said, yeah, we treat it like MU. Did I, type L instead of N by mistake? Is it, was it an error? And yet there's an awful lot of good faith effort on the part of the appellant that I feel for, but I don't know. I really kind of struggle with it. I mean, the additions that they made to the property were certainly for the, life safety related, that they wouldn't have been required to do had it just been a single family. But, as a 13-unit STRP entity, it's a little strange that you can run a 13-unit STRP, essentially a hotel, and not be sprinkled, but if you want to call it a hotel, you have to be sprinkled, and it for all practical purposes, is the same thing. And the neighbors raise an issue which I think is a little bit, I know Ms. Davis said, it's not technically rezoning because of maybe the legal, what it means to legally rezone, but as a non-lawyer, I consider it to be essentially rezoning, and the neighbors considered it to be essentially rezoning, and there's not a process in place, a public process that MDHA has apparently to, allow that type of input, and that was a little surprising for me too. So there's a lot of discomfort from my end about having to decide this in a way that that rules against MDHA's ultimate decision, whether or not I think it's fair.
Yeah, I do have the same kind of tug of war in my own heart, as I did last week with our last meeting with the appellant. When, if you get told something from an authority having jurisdiction, you should be able to take that to the bank, whether figurative or literal. I think, I don't know. I have a hard time ruling against someone that has clear information from somebody that says, this is how we're treating this, is how it's been done. And I know that it does happen when people make mistakes and people, and so that's why I'm having a tug of war in my own heart right now on this, of how that's viewed, because as an architect, it drives you absolutely crazy when you're told something and you get told something 2 or 3 times even, and then they say, well, actually, no, that's not it. But there is, I think, and part of that comes down to the formal process for making these determinations is not real clear, other than when you apply for a building permit. And as Mr. Hargis noted, when they applied for a building permit under multifamily, it was approved, and when they applied for that change of use in the hotel, it was not approved. So I'm kind of on the fence, I'll be honest right now, and I'm trying to process this myself.
So, yeah, the first thing I have to observe, because it's really interesting, a few months ago, we had a councilman up here, and I can't remember where it was, but somebody wanted to put in condo units that could be short-term rental, and the opposite, but you could actually put a hotel there without a variance, and I said, aren't you concerned about the fact that if you don't allow this, there could be a hotel? And the councilman said, no, we want a hotel that is much more control. We don't have the wild parties and all that kind of stuff. So it's just interesting to me that it's kind of the opposite today. So
I remember that. That was Sean Parker, and it was on Dickerson Road.
yeah, it was on Dickerson Road. Yeah, he much preferred the hotel. So at any rate, we had another one a few weeks ago where the permit hadn't been issued. I think there had been a grading permit, and the applicant really couldn't even enunciate any money he'd spent. $500,000 when you're told by someone, and it's undisputed. I think if there's a factual dispute here, that's something different. But they're clearly told they spend $500,000. To me, it is a case of equitable estoppel. I did have concerns about, do we have the authority to do that? And Mr. Hargis says we do. I don't. So that kind of resolves that for me. And so I think, I think the equitable estoppel applies, and that I'm not sure why the zoning administrator didn't apply equitable estoppel, but I think it applies, and that the zoning administrator erred.
Well, I don't think equitable estoppel necessarily applies, but that's why you have lawyers, and we make money doing the arguing back and forth. But there's, at the same time, there's also a theory that allows for an abstention, which means we don't have to take it, because I'm beginning to feel like sometimes if nobody else knows where to put something, it ends up in our lap. And I'm not so terribly sure that the battle isn't really with MDHA and not us. And I may be saying it nearly as succinctly as you did, Ashante, but I'm having a hard time getting over that particular part. I don't even think you have to get to equitable estoppel, honestly, to make a determination. I wish this had been an MDHA where it really does need to be. I don't think it needs to be with us. So, and I realize we may have, just because we've got jurisdiction doesn't mean we have to take it. So,
But who would
I'm
have
still on the
Who would
fence.
have jurisdiction if we don't, though? Because
Chancery
MDH does not issue the building permit.
well, they may not issue the building permits, but they can go there and they get someone that their job is to judge things if they're dissatisfied with the decision. That's why you've got courts of appeals, you've got Supreme Courts. I mean, you just work your way up the process.
So what you're saying is that if we, by default, if we said, you know, we uphold the zoning administrator, thus upholding MDHA, then Chancery Court would be.
Yeah, that's where they end up. And I think either side can make that determination. I haven't seen.
Oh, put your mic. Yeah, Mike, sorry.
Sorry. I mean, I think that frankly is why those people have that vested in themselves in the courts where it belongs, frankly. I mean, there are a lot of issues here. And cases of first impression are not usually favored. And I've honestly not just, I think both sides have presented themselves incredibly well, honestly. But I think someone else is, and I know I used this about you a little bit ago, kicking the can down the road, but I don't like it getting kicked over here. And I think we should just let it work its way through the system so there's some finality. You know, and then they make the determination. That's just my feeling right now. I'm going to keep listening to you guys. You may twist my arm and change my mind.
Does anybody have other thoughts or a motion to move this forward? One way or the other. Ms. Davis.
So I don't have any more thoughts. Does anyone else have any more thoughts? I'm going to try a motion and then we can discuss it and then see how it goes. And it might fail and then we can try another motion. I make a motion that based on the record and the arguments of counsel in the opposition, that we find that the zoning administrator did not err and that we vote to support the zoning administrator's decision.
There's a motion and there's a second. Further discussion of the motion. All right, no discussion. We'll call the question. All in favor of the motion, say aye and raise your hand. Those opposed, that motion passes 4-2. All right. Do we need, 5-minute break, then we'll hear the next case. And proceed with our next case, which is case 2020-118.
All right.
Mr. Hargis.
Yes, sir. The next case for the board is 2020-118. Get my screens, your screens turned, there we go. The subject property is located here on the east bank of Cumberland River, located in red, which you see there. An aerial photograph of the subject property. And these are some photographs I took of the before this case, showing the billboard from Korean Veterans Bridge, and then views from South 2nd Street, looking west toward downtown. The billboard located here. And then a second view from, I went a little further east on this, or north on this property toward KVB to get a better shot of that. The procedural history of this case, this Members, I don't have a lot to add personally. This case predates my return to employment with Metro government, but long and short of the case, the Codes Department issued a permit for a digital billboard on this property. After its erection, John Michael, the prior zoning administrator, issued a letter to the appellants revoking the permit, canceling the permit because it did not comply with the zoning regulations. This board had a hearing in which it entered an order upholding the zoning administrator, denying the appellant's request. The appellant filed a rehearing request based upon testimony provided at that hearing, and this board granted it that rehearing. And so this hearing today is the rehearing which you granted in 2020, in August of 2020. Question may come, why the delay? Why the time lapse between now and then? I believe there was some legislation that was filed at the council that would have permitted compliance from the Codes Department's perspective, that this board would be in compliance after that legislation. That legislation languished, sat for a while, ultimately was indefinitely deferred. At this point, I reached out to Mr. White here, saying, hey, it's ready to file your rehearing request. So that's what's before you today. You have received from the Planning Department a memorandum filed by Ms. Lucy Kemp, and one of her staff members, Ms. Lisa Milligan, is present should you have any questions of her regarding Planning's position on this case. But for the record, I've reviewed the case from before. I watched testimony of the first case and the rehearing request, and I reviewed the documents, and I stand by Mr. Michael's revocation of this permit. So I'm not setting aside his revocation. I stand by it. And with that, this appeal ensued. And so with that takes up my 10 minutes and my portion of the thing. Mr. Henry will have 10 minutes, and the other parties will also have 10 minutes.
Ms. Hargis, can I ask you a question?
Sure.
I believe the appellant, you handed this out, right?
This came from Mr. Henry.
Right. Did you get a copy of that?
I did, yes, sir.
Will you take a look at it? I know when we review the cases for consent and you give me an overview so that I can hopefully be a little better prepared to run the meetings, we talked about this flow. I think I brought it up because that was when I read the materials, I wanted to make sure that I understood just kind of what the issues were. Will you review this and see if there's any disagreements that you have? It seems to me straightforward, other than if you want to review lot frontage and what that means, because that may be a key part of their argument, and just to see if we're all on common ground so that we can use this as a very useful tool for knowing what the process flow is for being able to have a billboard.
Sure. I'll be happy if you'll give me a few moments.
No, that's fine. I mean, I was just giving you a heads up.
Sure,
so when we ask you about it in a little bit, we'll see if everybody's on common ground. That's a wonderful thing to have this, and it's very helpful. Thank you.
Okay.
And
I sure will. With that, I'll turn it over to the appellant. For the board's purposes, again, he gets 10 minutes. This is a case with opposition. The Codes Department is opposed to this case. So with that, I'll turn it over to Mr. Henry. Mr. Henry, I'll keep the clock here. I'll be sure to let you know at 5 minutes and then at 3. Are there any other parties besides Mr. Henry and his clients present who wish to speak on this case? Mr. Chairman, seeing none. So Mr. Henry will have 10 minutes and rebuttal, I guess, of any questions you have of me. So.
Thank you, Mr. Hargis. Chairman Taylor and members of the Board of Zoning Appeals, my name is Sean Henry, 500 11th Avenue North. With me here today is Russell Burdett on the far right. He's the real estate director for Outfront Media. And next to me here is Ken Church, a registered land surveyor with the Reagan Smith Associates group. We have filed both a memorandum of law with you regarding this case, the latest one. I think there's a total of 3 now. But also we filed with you this second hearing comprehensive exhibit package. It's a rather massive document. It includes the evidence that we originally submitted when we had our very first hearing. It includes the evidence that we submitted in that request for rehearing, and it also includes some newer information as well. We don't have time, as you can tell, to go through this document, so I'm going to do my best to highlight this and refer to that only as necessary and maybe to answer some questions. But one of the things that, we've got Mr. Church here today, but we also, in that original submittal, supplied letters and affidavits from a list of experts. And I just want to, for a few of the members who may not have been here during that first hearing, there's letters in this record from Michael Garrigan, he's a professional engineer, Jamie Gillespie, professional engineer, Michael Charette, registered land surveyor. We've also cited to various Metro sources, Metro code sources, Metro planning sources, state sources, and federal sources and regulations. And so I can direct you to where those, you can find those if you care to dive into that. To try to simplify the points of discussion here, we prepared this flow chart, and on the back of it is a photo, fairly, I guess, recent photo that my client supplied. And principally what I'd like to do here is just kind of walk you through this flow chart. And if I could, Mr. Burdett, if you could just hold that chart up. We've also brought this enlargement of exhibits that are already in the record, just so you can kind of follow along with what a permit writer, and I'm talking about the zoning permit writer, does when they sit down with an applicant who's applying for a billboard permit, how they process this particular section, this location section, which is item 12, that you can see up there in the right-hand corner of this flow chart. There's a lot of criteria that have to be checked off. Mr. Church has gone through that in one of his new exhibits, but the only issue that has been pointed out with this particular billboard location is item 12 that talks about the particular location criteria. And so we've summarized it in this flow chart. And the very first question to be asked is, does the lot frontage, does the lot have frontage on a public street? And so you have to look at how frontage is defined. And that asterisk takes you down to the bottom, and this is straight out of the zoning code, and I've cited to the section of the zoning code. Frontage is defined to mean any portion of a lot that abuts, and the term abuts is defined in our code as meaning touching or sharing a common point or line. Does any portion of the lot abut a public street? If it does, it's got public street frontage. The answer then is yes. The next question is, does the street have 4 lanes or more? In this case, with Korean Veterans Boulevard, the answer is yes. You jump down to the bottom, this site qualifies for a sign permit. Check the box. If the lot does not have frontage on a public street, then the next question is, well, is the lot within 300 feet of a limited access highway? Limited access highway, controlled access highway, those terms are interchangeable. They mean the same thing. In this case, is Korean Veterans Boulevard a limited access highway or a controlled access highway? We have a lot of evidence in the file that says that it is. We have Mr. Church that will speak to that in just a moment. Let's assume that it is, because we think it is. Then the question is the lot, in parentheses I put the word billboard, oriented to a limited access highway in this case? Now, this board decided this question solely on this point in 2020. Historically, we've got 50 years, and we've supplied you with 81 examples of where the Codes Department has interpreted that provision to mean billboard orientation. When you look at the billboard regulations, which are within the sign regulations, the sign code portion of the zoning code, it all talks about sign orientation, billboard orientation. We've listed in our materials line item after line item where it's talking about the orientation of the sign. And why is that important? Because it's the public policy, both at the federal level, the state level, and the local level, that signs are oriented to the motorist, So it's got to be oriented to the street in which the motorist is traveling on. The public policy is not to orient signs to a residential neighborhood, not to orient a sign into the side of an apartment building or into the side of an office building so that you can get the attention of those folks. The market doesn't want to do that anyway. That's a limited customer base. But nonetheless, the public policy is to make sure that signs and billboards are oriented to the travel way, and that's purposeful. In this case, we submit that this particular billboard, as the photo shows you, it's oriented to the highway. and KVB's as limited access highway, once again, you check the box, this lot qualifies for a sign permit. If the lot was not within 300 feet of KVB, then it wouldn't qualify and they wouldn't be able to get a permit. So that's the simple flow chart analysis just based on the or language in there. You either have frontage on a public street with 4 or more lanes and you qualify for a permit, or you're on a lot within 300 feet of a limited access road, and the board is oriented or the lot's oriented to that highway, you get your permit. We submit that this site qualifies for both.
So from your perspective, and this is really helpful, thank you, and sometimes the second go-around, it may be, the arguments may be clearer. They seem clearer to me in terms of what we have to decide. And so let me tell you what I think we have to decide, and you tell me if there's something else that's there. But it's the question of frontage and what is frontage, and if in your documentation you say there's frontage on Second, on First, and then you're also claiming that there's frontage on the KVB, and so it seems straightforward that, and we can talk to Joey about how they define, frontage, and see if there's any difference in your definition. But it seems like that if we determine that the KVB is frontage on this property, KVB obviously has 4 lanes for cars, and then you would, if we agreed to that, then that would logically say you're eligible for a permit.
Yes, sir.
And then the second is that if we say, well, no, the KVB, there is not frontage there, in our opinion, for whatever reason we come up with, since it's a difference in elevation, or again, not making an argument against your, not asking you to make an argument against your client, but if we said no to that, then we go down the next line of your chart, which says, is it within 300 feet of a limited access highway, which means that we would have to determine, is the KVB a limited access highway? And so really it comes down to 2 questions. Where does it front? And if it fronts on any of those streets, are they 4 travel lanes? So we do have to ask if the lanes on Second and First and KVB are 4 lanes. And then if we say, no, it doesn't front those, then we have to address the limited access highway.
That's right.
Okay.
Yes, sir.
So that's the logic that we have of the decisions we have to make.
That's right.
Okay.
And I would just point to page 277 in the large packet that we supplied, which is an excerpt of the definitions from the zoning code that defined frontage, defined abutting, defined frontage of a street where access to it is limited or it has no access, but it still has street frontage. And they give it as an example an interstate entrance or an exit ramp in similar streets. And many arterial streets don't have direct access. And we all drive down the interstate and we all see billboards, mostly, lining our interstate system. And for this board to decide that a lot that doesn't have frontage on an interstate, you then got to go into that 300 feet, and then you got to go into lot orientation, which is where we previously went. But mostly the interstate locations are decided because they've got frontage on that street.
Yeah, and I do remember us going down, spending a lot of time on the lot orientation, but I think that was maybe a hypothetical. Say, let's say that the KVB is a limited access highway, and I don't know. I'm still having still struggling with that. Whether it's a limited. I mean, for your lot, is it if it abuts? If we agree that it abuts the the property, then you really almost get your first argument, but.
Correct.
But it also, if it abuts, that may be the only way that would be a limited access highway for this piece of property, because it almost has to abut because every other property that it touches, and it's only because of the bridge that makes it limited access to me. And I know we went round and round. I mean, this is a new hearing, but that's the piece of it that I'm having a tough time with is KVB limited access, since I can't think of any other highway that I would consider limited access that, allows walking, biking, multiple access points that are not, regulated with signs saying certain, it's limited to anybody. I mean, there's no limitation. In this case, it's limited because there's a river and you have to have a bridge over the river, but not because of the highway itself. So could you talk to why the KVB, in your opinion, is a limited access highway again?
I can, but I do want to emphasize your point that just coming through the first analysis, you don't even have to get into that kind of detail, and we don't have to figure that out. There's frontage on KVB. KVB has more than 4 lanes. That's the end of the question. That's the answer. It qualifies. If we want to move into that deeper analysis of whether or not this lot's within 300 feet of a limited access highway, the term limited is only used in this section 12 of the zoning code, anywhere in Metro Code of Laws. So limited means controlled access. When that bridge was built, it was built by TDOT. It has a controlled access identifier on the survey. It has a controlled access fence. No different in these terms, and this is Mr. Church's testimony that I'm stealing, but it's no different the way this was built than the interstate. This was a TDOT project. It's a federal highway. It's a federal primary highway designated by the federal government, receives federal transportation funding eligible for that. So we've got all that evidence in here, and I can point to it as need be, page by page, but you've asked the critical question, what does it mean to have frontage in the first place? And the fact is that frontage does not mean you have access. Frontage does not mean that it has to be subterranean, elevated. It means none of that. It's a boundary. It's a line on a map. And that's why the Codes Department uses the parcel viewer map, which is filled with lines and nothing more, to identify, does this lot have frontage? And we've got Councilman Brett Withers, who just sent you an email saying he believes that the parcel appears to have frontage along KVB. So I'll turn it over to Ken, but he can answer that better than I.
Kenneth Church with Reagan Smith and Associates, 3115 Woodland. Now, on limited access, we conduct what we call American Land Title Association surveys. These are national surveys. They're the gold standard for surveys in every state. And in those, when we prepare, we have to identify all frontage, limited access and public frontage. We have to show the title company what is the limited access and what they can access. We even show the lane lines on there, because these surveys are then presented to a title report zoning company. They will go through there and look at it and make sure it meets all the zoning. I just recently conducted a survey this summer. It was sitting over on 40th Avenue, and on the north, it was frontage was on the interstate, and then you had a frontage on 40th. It had access off of 40th, which was a 2-lane road. The interstate in there is 10 lanes. There is a billboard there, and it faces the interstate. We have several other examples that we have discovered. We have 1, 2, 3, we've got 6 examples where the property has frontage on the interstate and there's an elevated bridge. So the right-of-way is underneath the bridge. In this case, KVB, they have frontage on KVB because there are fences back there that control the access going underneath the bridge.
So you can't go underneath on First Avenue?
No, I'm talking, on First Avenue you can, but there's a right-of-way, there's part of the right-of-way that's reserved for KVB that's underneath the bridge. There's a
Is there fencing that is meant to do anything other than keep folks out of the Titan Stadium, or is it?
No, right here, there's fence right here, which borders that. You can go down there, and it stops over there at the abutment where the bridge has an abutment.
So does that make it limited for that property? Because the property just above it doesn't have that fence, and you can just walk from that property right onto the KVB.
You talking about the parking lot?
Yeah. So, I mean, I guess.
Well, to walk on, to get on the bridge, you'd have to climb a wall to get onto the bridge from there. I know what you're talking about on the sidewalk going across the bridge, but it says on the map limited, and there's a fence back there that shows that. They control the access going underneath the bridge.
Okay.
Now, you can go on to First Avenue, and you turn and go out towards the stadium. They have recorded a plat on the parking lots in there. The parking lot underneath has air rides. There's some places that just says right away for KVB, and it's limited access. So you can't park underneath it.
So I'm sorry, just one quick, these questions about the limited access are what I would call track B, right? I mean, if we believe track A, that it abuts, or that it shares frontage with KVB, then we determine is KVB 4 lanes. We can see it. It's clearly 4 lanes, no parking. And so will you address your opinion as a surveyor on the frontage, and even though there's a bridge and there's a topography difference, how this property, or could you help make an argument how that property abuts the KVB?
Well, we would show that as part of the right-of-way of KVB on our survey. And then we would label that as limited access, that they could not go underneath the bridge on that. And like I said, we've done this before on several other sites where the bridges are elevated, and we put those on there as limited access. And it is frontage along KVB.
Okay.
Then you'll have a pier. You'll have a pier along in here that is actually spelled out as part of the right-of-way individually from the parking area. So the right-of-way is underneath the bridge except in some areas.
Okay.
But it would definitely call for as being limited access if we go that route. But it's a public street, and we call it a public street. We would put a statement on a survey like the subject property has frontage on 2 public streets. 1, 40th Avenue South, which is direct access, and a public street, and 2, I-40 with controlled access. We would label our survey showing that is a limited access.
Okay.
And we would show second, and we would also show that, and we'd show all the bike lanes also.
So I have a question. So you can see on your map there's a corner of the property that goes underneath the bridge. Is that part of your property, and they have an aerial easement goes above it?
No, our easements, the frontage stops at that fence. There's property markers back there, stops at that fence. That fence marks the right-of-way for KVB.
Okay. And I have very recent experience with this site because I walked right through here on my way to watch the Titans lose a couple weeks ago. So I'm just making sure that I have all my bearings straight here. So you would contend that your property stops where the line shows kind of on that map, right? Okay. And but your adjacent property, so it looks like it at least on there, it goes kind of underneath. So yours does not go underneath the bridge at all.
No.
Okay.
Some of the parking area has been platted and is underneath the bridge.
Okay.
But not all of it, because they took the abutments and called that the right-of-way.
Okay.
But the TDOT maps do show it as limited access.
Okay. Thank you.
Any other questions right now? All right, continue.
Well, just one comment on, related to that topic is, and I've just highlighted the property boundary that abuts the right-of-way of Korean Veterans Boulevard to help you see that. But we have a definition in the Metro Code of Laws. It's in the Traffic Code, Title 12, regarding controlled access highway. That definition means every highway, street, or roadway in respect to which owners or occupants of abutting lands and other persons have no legal right of access to or from the street. So this property has no legal right of access to get on the bridge. There's other properties that have been granted that kind of access. You can imagine the bridge building that's allowed to have access up to Shelby Street Bridge. We're allowing some of the development in the Gulch, the Amazon developments, to have an access onto Church Street. So there's situations where we as a city, have allowed adjoining property owners to have access to a limited access roadway with either pedestrian connections or driveway connections. That doesn't exist here. This is a controlled access, otherwise known as limited access. Those are interchangeable terms. And so this property certainly has frontage on Korean Veterans Boulevard, right-of-way, and qualifies.
So that right-of-way is owned by the state?
Yes.
Yeah, I guess that's, I want to clarify that too. That space, so like, I'm looking at Google Maps here, but looking from First Avenue, there's like a triangle of space there. It's got a sidewalk going through there. It's got gravel. It's got stuff. There's, people tailgating on Titans games. So that is solely owned or solely accessed by the state of Tennessee. Is that what I'm understanding from you?
That would be the right of way for the state of Tennessee.
Okay.
Any other questions at this point? Did you all have?
Mr. Chairman, regarding the state of Tennessee, I would just reference that beginning on page 307 are the original construction drawings, including the right-of-way acquisition maps. So we've included certain pages of those, including their legend, which is a standard legend that they use when KVB and the bridge was built. And you'll see in there we've noted where they label it as proposed right-of-way, CA meaning controlled access, and fence, and how they label those things. And those are labeled on the original drawings, and they're in the record, again, between page 307 and page 312.
So, sorry, I'm just still getting my bearings straight. So the sidewalk, there's a sidewalk that goes straight down alongside. Is that on your property, on the property in question, or is that owned and maintained by somebody else?
The sidewalk on First?
No, it goes underneath the bridge. There's a sidewalk that goes underneath the bridge.
It goes underneath the bridge.
Okay. That's on the adjacent property that goes underneath the bridge. Okay. Sorry. Now I'm seeing it better. Okay.
Mr. Chairman, I've saved the legal arguments that we've put in our legal memo. I'm happy to touch on those. They're clearly, we've cited everything, but I'll just touch on those very quickly. When the zoning administrator makes interpretations and decisions in the administration of the zoning code, our zoning code requires the zoning administrator to do so in a manner consistent with federal law and other ordinances and codes, including the Major Street Plan, the State of Tennessee Outdoor Advertising Regulations, and the Traffic and Parking Code. So the interpretations are not made with blinders on, only looking at the zoning code. The interpretations have to be consistent with other codes, and including federal and state regulations. There's four reasons why we think legally that Outfront Media, our client, is entitled to retain this billboard exactly where it is. First of all, the Vested Property Rights Act of 2014, essentially, in short, once a permit has been issued, and in this case, not only issued, but the building built, the sign built, and made operational. Once that happens, you have crossed the point of safety, so to speak, where the government is precluded from interfering with your right to use the property in accordance with that permit. So this thing was not built out of sync with the permit requirements. There's no evidence to suggest that Outfront built this billboard structure out of compliance with anything. It strictly meets the construction requirements, and so it complies with the specifications and conditions of the permit, and therefore the Vested Property Rights Act applies and protects this billboard. Secondly, the interpretation that's been made now is in effect changing the zoning. You just had a discussion about whether there was a change in zoning on a prior case. We now have an interpretation that's changing the historic interpretation of this provision and essentially saying that this site is not eligible for a billboard contrary to the requirements for locating a billboard. So it's a change in the law is what has happened here. And we think that means that it made this billboard non-conforming after the permit was issued. We think that billboard is protected under the Non-Conforming Property Rights Act. Thirdly, the interpretation we think would be legal if it was going forward. If this board wants to decide this in a manner that is prospective on future permits and future interpretations and how the zoning office is going to administer this, that's fine. You have the authority to do that. You do not have the authority to interpret an action and apply that retrospectively, particularly singling out this particular billboard, because the change in interpretation that was previously considered by this board would apply to all 80 billboards that we've put in front of you as evidence that were permitted in the same manner on similarly situated property. So the decision and enforcing your decision on this particular billboard would be singling it out as selective enforcement. Fourthly, the Outdoor Advertising Control Act of 2020 that was pending at the time that this permit was revoked, we submit that pending legislation at the state level protects this billboard. And in fact, when that law passed, what that law did is, you may not be aware of this, but the billboard law in Tennessee was outlawed by the federal government as violating our constitutional free speech distinctions. And so there was a year where TDOT wasn't even issuing permits for billboards along the interstate system. It was in limbo. Well, the Outdoor Advertising Control Act adopted those new provisions, and what it did was it removed the distinction that the federal court found problematic, removed the distinction between on-premise signs, business signs, and off-premise billboard signs. You can no longer make that distinction. And so we have this new state act that cleaned that up. But Metro hasn't done that. Metro has not yet done that. Metro zoning code and sign regulations still distinguish between on-premise signs and off-premise signs, billboards. And there's a recent case out of the city of Austin, Texas, that refused to issue a permit because of the distinctions that city was making, as Nashville still does, between on and off-premise signage. And the U.S. District Court of Appeals in the Fifth Circuit held that the sign code was unconstitutional because it distinguished improperly between on-premise and off-premise signs, quote, to protect the aesthetic value of the city and to protect public safety. The U.S. Supreme Court has that case in front of them. They're going to take that up. They've agreed to take that up. We're going to have a decision this summer from the U.S. Supreme Court on that issue. So Metro's sign control provisions are suspect. And what's fascinating, though, when you look at the sign regulations for on-premise business signs, there's provisions that talk about, and let me just read it. Section 17.32.130D, on-premise ground signs in an industrial zone, which this property is. If it were an on-premise ground sign, if this business owner wanted to have an on-premise ground sign along KVB, they could do that. They could do that. Because it says properties directly abutting a controlled access highway along the frontage of that highway can have a sign 1 per 1,000 feet of highway frontage. A sign oriented to a controlled access highway may be as large as the maximum size of a sign down on 1st Street or 2nd Street. They even talk about substituting controlled access highway frontage in feet in lieu of lot frontage in feet. and the maximum height of a highway ordinance sign shall be, in this case, 30 feet above the finished elevation of the nearest travel lane to the highway. This billboard meets that. This billboard is no more than 30 feet above KVB. It complies with the on-premise sign regulations, except for size. It's larger because we have a Type 2 billboard and they're bigger. But that's the only difference here. That's the only difference between this sign talking about the business that's located on that lot and advertising other businesses and services is the size of it. But otherwise, you could have a sign there that meets the criteria that I just spelled out that would apply to the business itself. So with that, Mr. Chairman, we're happy to answer any questions and refer to what we have in the record. We'd like an opportunity for rebuttal if there's going to be any further comment.
Any other questions at this point? Was there opposition present? Okay.
Can I make one, in that case, can I make one final statement?
Sure.
We also have in the record a list of contracts that were executed with a number of national entities. What's fascinating about this particular billboard, this all came about during the COVID-19 when that really hit in February of 2020, and that's when the permit was revoked. So the permit was revoked in February of 2020. In April, a few months later, the Metropolitan government executed public service announcement contracts with my client to use their billboards for PSAs relative to COVID-19 instructions and health protections. And so this billboard was used by Metro from April of 2020 to December 31st of 2020 with public PSA announcements. The state of Tennessee used it as well. But it's just a bit ironic that a billboard that Metro revoked the permit on continued to be used by Metro. Thank you.
All right, thank you. We will close the public hearing. This is helpful. And I think we may have gotten to some of those paths when we heard this before, but and I do think it's the correct order, right? I mean, if we think it fronts the KVB, then we decide if KVB has 4 travel lanes, and then we decide that the lot qualifies for a sign permit. And so, Joey, if you have a chance to review this, and
I have, Mr. Chairman. The chart itself, I don't disagree with the flow chart. I may disagree with the terms that the appellant uses, but
on frontage, and I guess I would assume that you have the opinion, or that your office had the opinion that it doesn't share frontage with the KVB.
We do.
So how would that? Because if it did, then we wouldn't be here. So how does it not share frontage?
Well, for purposes of record, I would ask that this board give Mr. Henry the ability to rebut my testimony. But as I stated at the beginning, I did not reassess this de novo for the lawyers on the board. I didn't rehash this case in my own mind whether we should have issued it or not issued it to begin with. But you've asked me the question, so my answer is I don't believe it has frontage on KVB because and I'll show you examples in the zoning code where we talk about frontage. But I also disagree that KVB is a limited access highway. I disagree that first and second have 4 travel lanes. I don't believe that bike lanes under the zoning code are considered travel lanes. I do understand, and I appreciate Mr. Henry's direction that travel lanes, I'm to look to Public Works and their regulations. But when this zoning code's written, and I guess maybe I'm burdened by the history of being here when it was written, so I know the steps in the evolution of this code. There were no biker travel lanes in our code when this was written. So to the question of does it have frontage on the zoning on KVB, it adjoins KVB. I do not consider it abutting, as though I cannot drive down KVD and turn right into the subject property. I can't get there. I have to go down to second, then come around, then enter the subject property. And I'll give you examples in the zoning code.
But how does it, if abuts, they're saying that abuts means touches or shares a common point of line.
It does, but I guess I guess I would say that I take abutting to mean on a two-dimensional plane that they're physically touching each other. They share a common property boundary. This bridge is elevated above the subject property. I don't consider that abutting. Now, that court may ultimately say I'm out of my mind or they disagree with me, but I don't believe I can get from the bridge to the subject property simply by walking across a horizontal plane to get there. And that's all throughout our zoning code is written that way. I'm happy.
So if it were not built on a bridge, but it were built on a mound of dirt, like lots of bridges are, and the state owned the mound of dirt, which it owns the land under the bridge, and my property touched the mound of dirt, would that be abutting?
I would tell you that in this instance, if the KVB bridge started, can you see my cursor? If that bridge began to elevate where my cursor is, that abuts KVB. KVB has 4 more travel lanes. It's on the same plane as the surface, as the property itself. But let me show you because I think it's important.
I'm sorry to interrupt, but so the parking lot next to this property, in which you can walk from that parking lot onto the sidewalk of the KVB, they could have had a billboard if they're wanting 1,000, 1,000, if they met all the other criteria because it abuts the 4-lane road.
To me, and I'm just going off my recollection of taking this photograph here, nowhere along the subject property is it on the same plane as this street. So look at this photograph. I can't get from KVB to the subject property. There's no way to get there. So although it's neighboring, it's beside, we've just always interpreted butting to be on the same physical space. Because to say that then, in any property in which a bridge elevates over, take Church Street near NES, those properties in the Gulch, those would be abutting Church Street. I disagree with that. I don't think they're clearly adjacent. They're clearly.
But there are billboards on that, right?
Right. But I'm talking from the sense of trying to apply the words in the code consistently through the code. Because if I were to take Mr. Henry's position and say, oh, these are clearly abutting, in the sign code, let's take, in the same sign code section, we base signage based upon your lot frontage. So we don't issue ground signs for elevated bridges in the sense of, as you see at this table, how much lot frontage do they have? We base it off of the linear street frontage they have, in which I can access the property from that linear street frontage. Mr. Henry's right. There's notes up under there that give you additional signage being along a controlled access highway or give you additional square footage.
So how many square feet was this sign, do you know?
I would let the applicant cover.
And so, but it was bound by this, so I guess what frontage, do you know what frontage was used to?
Well, I think Mr. Henry, again, I wasn't here when the permit was issued, but in Mr. Henry's testimony is that the zoning examiner went through and checked the boxes in his belief that it has frontage along this street. And that may have been the interpretation of Mr. Michael here. I don't agree with that interpretation at all. All through this code, I'm just highlighting the word frontage, and there's 14 locations in just this section of the zoning code, but take the adaptive residential section. Residential uses are permitted on CS lots in an existing building in the urban services district, having a majority of their frontage on an arterial collector street. So if I were to take Mr. Henry's argument, I have this lot, neither first or second are arterial or collectors, but this elevated bridge just happens to be by. By this definition, I should allow them to do adaptive residential use on it. I just reject that notion on its face. That it has frontage, but the flow chart, your original question, sure. I mean, I agree with this chart.
But in that case, it doesn't have the majority of its frontage on the arterial street.
Yeah, well, I'm pointing out the definitions of frontage throughout the zoning code, and to use that word consistently through the code, I've got to apply it consistently through the code. I wouldn't apply it any other way. I wouldn't apply it in sign code one way, in Chapter 16 something different.
All right. So, but by that statement, though, if it says majority of frontage, it means that there can be more than one plane that is considered frontage, right?
Sure, there's multiple. I mean, when I look at the applicant's subject property, they have frontage on First and Second.
What is that diagonal front?
This here?
Yeah,
This is KVB's elevated right-of-way.
I know, but but if you were to say that angle fronts the right-of-way but not the KVB? And
I
is
would
there a
consider,
difference?
I would say so, yeah. If KVB, if Korean Veterans Boulevard were at grade running along this property, and then once it crossed First Avenue, the bridge started, I'd say he meets the definition and would be allowed a billboard here, because he clearly fronts KVB at same grade, more than 4 travel lanes. You know, there's a center turn lane, I think, inside on the KVB here. So from the standpoint, I guess I sort of do look at it, you know, based off this question under a review that I don't think this permit would have been issued today.
Okay. Any other questions for the zoning administrator? Does anyone have an objection to allowing the applicant a chance to rebut at the zoning administrator's request? All right, I'll reopen the public hearing and ask for your thoughts on what you just heard.
Well, just real quick, I want to refer to the Gateway Boulevard design guidelines. There's an overlay in here. There's a definition of frontage. This applies to the Gateway portion, which is on the other side of the river. Frontage is a portion of a building or parcel abutting a public right-of-way. This is the right-of-way expert. I'll let him speak to that.
In this case, the right-of-way is underneath the bridge. The bridge is built above the ground. The right-of-way is air to, all the way to the ground. There are places that when they mapped out the parking lots in there, they reserved some of those air rights underneath the bridge for parking, not the total length of it. We have 6 other examples where signs are abutting, have frontage on right-of-ways where the bridges are elevated. So we got on page 177, Exhibit 51, page 83, Exhibit 53, page 199, Exhibit 59, page 219, Exhibit 69, and page 237, Exhibit 78. Those are all signs that are adjacent to a bridge which is elevated. The right-of-way extends all the way to the ground.
Okay. Any other questions?
Well, I just, there's a forced interpretation taking place here so that this billboard comes down. And it's a forced interpretation that is new, fresh, never before applied. And we've got example after example of how this has always been treated. The definition of frontage is merely abutting the public street. And the street is the right-of-way. As you just heard, that right-of-way line, that boundary line, as you own property, and your property line, it runs from center of the earth to the center of the sky, to the heavens. So it's straight up and down. There is no element of elevation or grade change that is in the definition of frontage. There's nothing in there. If the Metro Council, and that's really who adopted this code, if the Metropolitan Council felt the need that we need to distinguish the term frontage to be different than that single line that abuts a public right-of-way, then they would have made an exception in there or a delineation between elevated elevated streets where there is no access. The issue of elevation and the issue of access is irrelevant. It's got nothing to do with it. Whether the lot has frontage is based on the survey criteria.
All right, any other questions? Then we will reclose the public hearing.
Well, I mean, oh man, I guess now, like, I can look at each one of these that they noted and agree that it is abutting with the height. I don't know. I'm saying it's really poorly, but it's alongside a bridge. I'll put it that way, where the lot is lower than where the sign is. You know, and if we could, you know, if I could get rid of them all because they're ugly as sin, then I probably would. But that's not what we're here today. We're here today to determine the legality of this. So I'm going to ask the attorneys in our group, because you guys, you know, what are your thoughts, or maybe it's a better question for our legal counsel. I'm not sure.
I think it's a capital suggestion.
Okay, so what, if any, you know, basis of precedent are these other signs being in, you know, in locations, in possibly similar locations, in regards to the right-of-way versus the right-of-way being a vertically different than the frontage. Am I saying that right? Okay.
And so just to clarify the question, you're asking, what you're saying is in previous situations, you've granted similar variance requests?
Well, similar sign permits. I mean, they have six or seven here. Other signs that are installed around town that with seemingly a similar thought process is probably why they were, and I'm not going to infer on why they were installed.
It's not exact, just similar.
Yeah,
okay.
Similar characteristics, I'll put it that way.
And at this point, you're wanting to know if the zoning administrator erred by not ruling similarly with this situation as he has with similar signage?
Well, I'm asking, do those create a precedent for this to go for this case?
I'm inclined to say no. I mean, unless there's case law, or are you just simply saying situations that's come before the board? I mean,
I don't think you're saying that these have come before the board.
No, they haven't come before the board.
and maybe I'm misunderstanding.
I guess you're just saying that if
this pattern, does this show a pattern that creates precedent for a similar interpretation to be applied for this case?
But each of the facts on these other ones,
Yeah.
we don't know the background.
Yeah.
There may be
Right.
separate and distinct issues. And in the terms of a federal judge who used to call me down all the time, you're assuming facts not introduced into evidence. Next question. So
And that is why I'm not an attorney.
Which means you're smarter than most.
Let me ask you a question. I mean, it seems like that if we don't even have to address the messy parts of track B, unless we exhaust track A, which is the frontage on the public street that has 4 lanes, and the obvious one is the KVB. If we think it fronts KVB, then I think we're done with, or at least we have a path to an answer, because that path is fairly clear. If we don't believe it fronts KVB, then we have to address First and Second Avenue and whether or not we believe a bike lane constitutes a travel lane. And if we do believe that, then we're done. It's only then that we would go to the question of the limited access highway. So I think this chart's really helpful for us to not worry about all the possible paths, and let's just start at the first path, which is the KVB frontage, and because that one, to me, is the clearest path to a concrete answer.
Wait, can I ask you a question?
No, you were going to speak. I'm sorry.
No, because I think you just nailed it. I think you just crystallized that perfectly, what we need to ask ourselves. I guess my only question is, before I can get to your question, is I was reading through the packet and I saw the letter from the planning director, and it seems like her analysis went down that second path on why they why they agreed with the zoning administrator's sort of initial decision. And so I guess I'm wondering why they didn't go with the first question and see it that way, because they deal with frontage as the codes department does more, frequently than I do. And so I don't know if it's appropriate for, I see Ms. Milligan, but to ask her sort of why that analysis occurred that way, why they didn't answer it that way,
Yeah,
so that was my question.
I think it's perfectly fine. We can ask staff questions at any time, and then we can determine if we would like to hear back from the appellant. But if you have a question for the planning staff, that would be, I think
the way you stated the question was perfect. I want to know why they didn't look at it the way that you sort of crystallized, like why they sort of foreclosed the first option and went to the second.
So the question is, and the zoning administrator gave an opinion on that too, which we can talk about. I think that's part of the discussion. And I think it was part of the discussion last time, but I think it may be a little clearer this time. But introduce yourself and tell us your thoughts on that question.
Certainly. My name is Lisa Milligan. I'm the Land Development Manager for the Metro Planning Department. Thank you for letting me come to your all meeting today. I don't come here frequently, but I've found myself here a few times recently. So we did provide a memo. We wanted to outline some of the work that the Planning Department has been doing, a citywide process that the Planning Department has been doing related to the East Bank. And we wanted to outline some of that process and what we're hearing from the community as it relates to the East Bank. And so you've got that memo where we're outlining the public process that's been taking place with the planning and redevelopment of this sort of vast undeveloped area that's on the East Bank. A lot of what we're hearing is that people really want to have pedestrian scale urban boulevards with signage that is reflective of those types of developments. Mr. Henry brought up that this area was in a gateway boulevard, and one of the things that special policy or supplemental policy outlines is that signage should be pedestrian scaled to serve urban boulevards. And so from looking at it from a broader planning perspective, this type of signage is not consistent with sort of the existing supplemental policy, nor is it in keeping with what we're hearing from the community in regards to the East Bank study. So from a broad planning perspective and policy perspective, that's our opinion. From a zoning perspective, we agree with the zoning administrator in their determination that this lot does not have frontage on Korean Veterans Boulevard. Similar to what Mr. Hargis explained, when we're thinking about and talking about frontage, we're very much talking about direct access. When we're reviewing building permits or someone being able to get a building permit, when we're reviewing zone changes, we're really looking at how a lot is oriented and fronting and getting access to the public realm, right? And so from our perspective, this lot has frontage on First and Second. It does not have frontage on KVB, and that really does come down to how you access and can operate from the space to that lot. So we agree with Mr. Hargis in that interpretation. We also agree that Korean Veterans Boulevard is not a limited access highway. Korean Veterans Boulevard is more than just the bridge that this property happens to be near. Koreans Veteran Boulevard is a long stretch of road with many access points, many intervening driveways, and many intersections with roads. So this is not a limited access highway. Because you can't access a portion of the property underneath a bridge, likely for safety reasons from a state standpoint, does not make it limited access. This is a highway that has sidewalks, and many driveways and streets that intersect with it. So we do not consider it to be a limited access highway. Thank you.
Any questions?
I do. If there was a building on this lot and the building had, let's say, a second story that connected to KVB, would you then consider that to be frontage?
I mean, I think probably no. I think there's some unusual situations. I think the bridge building might be sort of the only sort of situation that we have, and it's a very unique sort of situation. I don't think that we would still consider.
Raymond James building on is it Demumbrian? What's it? No, it's not.
Yes, the Demumbrian has the bridge, the Gulch Crossing there.
Yeah,
that
the
connects
Gulch
in.
Crossing.
Yeah.
So, I mean, the Raymond James building, that I think you can access it from the Gulch, but you actually can pull in and enter the building on the bridge. So does
Yes.
that have Demonbreun frontage or no?
I would have to look at that. I don't have those plans in front of me, and so I wouldn't want to just sort of make a judgment call based on my knowledge of how it exists. I think I'd have to look at it. I know that that was reviewed by our team for its compliance with downtown code standards, but I would not want to make a judgment call without having sort of the plans in front of me.
I guess it has vehicular access from both the lower and the upper levels.
Yes, it
correct?
does.
Yeah.
Like the Pinnacle
That's
building?
Yeah,
Off
like, yeah,
off the Shelby Street?
right, yeah.
All right, any other questions for, all right, thank you. All right,
So,
we're still, public hearing is closed, but did you have,
public hearing is still closed?
Yeah, I mean, if you wanna-
Yeah,
if
no,
you
I was
wanna-
gonna say, I mean, here's the way I view it. With the definition of frontage, I don't think Mr. Henry is an error, and I don't think the zoning administrator is an error, because I think it's ambiguous. I mean, I don't know, it's just, if they would have put in the definition, it must be the same grade, then we would know. So, because it's ambiguous, and I don't think I can say the zoning administrator erred. That's just kind of where I come down on it. I mean, I think we as a body can debate for a long time, what does a butt mean? And does it mean that it has to physically touch it on a two-dimensional level, or can it be, elevated, but they still have a same common point? And we could do that, but I think, they're both, an argument can be made that neither Mr. Henry nor the zoning administrator are in error, and the tie goes to the zoning administrator, the way I view it.
so let me ask you, I mean, and I appreciate it, but the only part of that I'm having trouble with is I'm just mentally touring the city, and based on this argument, I mean, there are billboards that go down to Demonbreun, over that bridge, which is a 4-lane public street. We've heard, early on, there was and when I was on this board, there was a case about wanting to go to put a billboard on Broadway, and there's a whole lot of pushback from folks, and I think I voted against the billboard in that case because I didn't think it was a 4-lane road, but a majority of the board did say, well, even though 2 of those lanes are parking 23 hours a day or 22 hours a day, that it was really 4 travel lanes, and it was eligible for the billboard. And so there are billboards all over town, but I keep thinking, just the case of, if this thing was on dirt, they'd have a billboard. And it's not on dirt, but it's not on dirt because of an engineering choice or because First Avenue runs there. And I'm talking about dirt with like a berm, because we've had other billboard cases, and again, most of the billboard cases we don't get because most of them, it's determined they meet codes or whatever, we don't see them. But we've had some that were on the inner loop that, on the interstate, that I think they were too close to, maybe, by a few feet to residential, neither here nor there for this purpose. But that elevation is a whole lot higher than the dirt. The elevation of the road is a whole lot higher than the dirt it's on. And it was never a question about, does it abut because the dirt went up? Could have easily been a bridge. And so there's something about the line that, what does it front? If it fronts the right-of-way, is the right-of-way different than, than the bridge? I mean, and I don't know, that to me is that question, and it's, it has to front something, and I guess they can say, well, I don't think it fronts the KVB. Fair enough, but what does it? It's the right-of-way. I don't know. There's something about it that to me that says I'm not convinced. Now again, I think there's ambiguity, and where does the tie go?
I agree with everything you're saying. I have the very same questions. I just come down to how do I resolve it?
Well, then let me see. The logic is because
are you saying who has the burden in this instance? Because 50-50, we know who gets it, but who has the burden of persuasion?
Well, I think it's up to us to decide when do we have a belief based on the law. Is it one way or the other? And if we can't decide, then your question is, you're right.
Well, actually, that's the benchmark of an appeal is who has the burden in this instance of persuasion. That's the law.
Right.
Okay? Not what we feel, not the feel good or anything like that. So, I mean, for me, it's not really that hard of a response. Was there an error? Was there an arbitrary action on the part of the administrator or any of those things? Seeing none, we then come to the next levels that you're getting
Well,
to.
then if you say no, there's no frontage, then you go to, is this a limited access highway? And, is the whole, and then what is a limited access highway? I mean, is it the whole stretch, which I don't buy, or is it that parcel which doesn't abut because it's limited access? And so it is clearly a highway. And does that frontage, because that frontage has limited access, does it make it, a limited access highway for that property? And therefore it, if the billboard's oriented to the highway, it's okay too. Or is that ambiguous enough to not know? I don't know. I mean,
I'll just say we have a lot of letters from a lot of professionals that consider KVB a limited access highway.
well, and the active council member of the district, in his opinion, thinks that it actually fronts the KVB. And so, but then we have other professionals that say they don't believe it fronts it. So,
Well, that's true too.
there's a path.
We
There's a
rely-
path for either answer, but like I said, as you said, the professional saying it's at least limited access. Some believe it's in whole, and some believe it may just be in part. But
Well, and I'd say if the question before me was, is Mr. Henry in error in his positions, my answer would be no, because I don't think he is. But that's not the question before me. Is did the zoning administrator err? So that's. And I have the same answer to that, which is no, because to me, there's ambiguity here.
And I agree with Mr. Ross completely. I don't even need to add any words.
other discussion? Someone?
The only discussion I keep thinking through all this is just still that I don't know, which I think gets back to Mr. Pepper's and Ms. Davis's point of the ambiguity, and where does that push to? So.
Well, so, and I'm just going to ask on this one, and I get it. It was muddy before, and it's still a little muddy. But the common point, or the only thing to me that's triggered me this time is that if the lot next door, because you can walk onto the sidewalk, could have a billboard, again, assuming that there wasn't one, within the linear footage or what have you. And this one can't, only because the road's raised. I think I don't know, there's something about it that says, and that conflicts with a lot of other billboards in town on Church Street, on Demumbrium and whatnot. If that's where we're going, then that, and I may have made the opposite argument before, but I didn't have in my head, well, hey, the lot next door could have it. So, but that's where I'm a little bit, but again, it's still, I get the muddiness, and we can somebody can make a motion, we can take a vote and see where we are and move on. I don't think we're going to find any more information. But we could clearly muddy it up a little more if we want to also. Thoughts? Motion?
I'm going to make a motion that we deny the appeal and uphold the zoning administrator. get forward.
There's a motion and there's a second. Any discussion on the motion? All in favor of the motion, say aye and raise your hand. 1, 2, 3. All opposed to the motion? 3-3.
Mr. Chairman, under your rules, this case will stay on our agenda for the next 30 days. Mr. Cole is eligible to participate should he wish to review the case and participate. You members are also permitted to change your vote within the next 30 days, at the next hearing, not between hearings, obviously. And with that, this case will be scheduled again for, Mr. Henry, we actually have 2 dockets in the next 30 days. So there'd be 2/17 and 3/3 are the next 30 days, given how February runs. So, all right, that case is tied up on votes. And
that one will be held up in votes, and we will see. We'll talk about it next time. Somebody can change their vote, or Mr. Cole can watch the record and participate. And does anybody need a break for the last hearing? We'll go to the last one. Great, thank you all.
Thank you all.
Okay, the last case on today's agenda, case 2022-018. Okay. MTC Homes Incorporated, the appellant Nathan Dale Stoops Real Estate LLC, owner of the property. Property is located at 1018A and B Alice Street, requesting a variances from street setbacks and side setbacks in the R8 district. The appellant is constructing 2 single-family residences referred to the board under Section 1712-020A and 1712-030A3. The appellant has alleged the board would have jurisdiction under Section 1740-180, Item B. Are there any parties present opposed to this case?
Are you, Ms. Henry, are you all opposed? Y'all are opposed to this?
Okay, I just want to make certain. Sir, as you've seen in other cases, you'll have 10 minutes. I will go through the presentation first and then turn it over to you. And then you'll want to save some of your 10 minutes for rebuttal after these gentlemen speak. And I'll let you decide whatever time you'd like to do. The subject property is, there we are, is located on the south margin of Alice Street along the Cumberland River. It is in the R8 zoning district. This aerial photograph of the subject property.
And these haven't been built, right? I mean,
no, sir, they're not under construction.
Okay.
As of yet. So yeah, I apologize for that actually showed the the former residence on the property. That building has been removed. I forget in my slideshow here that you don't see my pointer. So this former structure has been raised now. And I'll preview just one. This is the current lot as my visit last week. So the site plan that's been submitted before you is a request to build a duplex structure, commonly called an HPR is the type of ownership interest involved in this. But the request is to place the residents, two variances involved here. One is a side setback request of 2 feet in the variance. The zoning code requires a 5-foot setback. The applicant is requesting a 3-foot setback. The second variance is street setback. His setback based upon the average of the contextual street survey, which are these 4 lots here, 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 and here. The average of those lots are 53.39 feet. He's proposing a 33.95 foot setback, so there's your variance of roughly 19.5 feet. This is a view of the subject property upon my visit. A view of parcels to either side, to the east and west. Bottom left is if I'm standing out just to the right-hand side. And other views looking along Alice Street, east and west there. So I'll leave the site plan back up. Sir, with that, if you'll identify yourself, push the button there and make your presentation. You'll have 10 minutes, and once you complete, I'll let you know what time you've got left.
Thank you. My name is Eli Ruth. I'm a representative and builder for the owner of the property. And we are, as was clearly stated, we are looking to a variance on the front and side setbacks at 1018 Alice Street. And I apologize, my address for the company is 406 Santa Fe Pike. We actually have changed our address since this was originally submitted. We have a new office now, so that could be updated. Our reason for this, and one thing that I like to point out is one of the reasons why we are requesting this is because when we originally went to look at building on this lot, we had no knowledge or access of the floodway buffer, the 75-foot floodway buffer, which you can see on the site plan. But one thing we were obviously using was parcel viewer. And it was one thing that we could not, that we were not aware of on parcel viewer. So that is our main reason for this, that floodway buffer, which a few of the properties up and down the street, some of the existing properties are actually built inside that 75-foot buffer. So I feel like utilizing some of those setbacks, especially, for instance, like 1014 Alice Street is, a little bit in question there because, again, it is built inside that proposed 75-foot floodway buffer off the Cumberland River. And that is really what we're looking to do there. We, really don't see a whole lot of encroachment on any other part of the street or anything. We actually noticed that the house to the, it would be 1020 A and B was granted a variance previously for this same reason because of that Cumberland River buffer.
Do you know what the grant, was the variance just a front variance or did they get a side variance too?
Yes, sir. It was just a front, from what I understand.
And so why is your lot different that you would need a side setback?
To be honest, the owner had requested that we see if it would be a possibility of getting the side variance as well, just because we had so much of our lot, our buildable lot area cut off by that buffer. That was...
But you didn't have any more than your neighbors, right?
I'm sorry, what's that?
You didn't have any more of your lot cut off than the neighbors?
No, correct. Well, compared to, I guess you would use 1020 as an example.
So, this would have been consentable with just the front setback. It was the side setback. I mean, just because and again, I don't know if my fellow commissioners would have, agreed, but I would have considered that just because we've done it on the street and there is the flood issue, but it's the side setback that I didn't see, the hardship for, and that's, I think, why your neighbors are here to object to just the side setback based on the letter
understand.
that they've submitted.
Yes, sir.
So what is the hardship for the side setback?
That was more of just trying to find a little bit more buildable area, from what I understand.
Okay.
On here. But more, obviously, more importantly, looking at this from a top-down view, the front setback was the original, when he presented this to me, I said, that was kind of our original route, was going for the front setback variance.
Okay. Any questions? Did you have anything else to add at this point?
No, sir.
Okay, then we'll hear from the opposition, and then you can come back and rebut. All right, if you would, state your name. You heard the routine. State your name and address and why you're here.
Good afternoon. My name's Luke Pierce. I'm the property owner at 1020 Alice Street. That's the property located to the west side of 1018 Alice Street here. Just in noting this as well, too, having developed the property here at 1020, we did receive a front setback, but this lot and the lot next to us in question here at 1018 is not unique to anything else that's on this street here. In fact, actually now seeing this plan in front of me here, I would argue further that the front setback that's granted here actually provides a greater buildable space given the curvature of the river. If you see the setback from the river at this point, actually the backyard 75 setback that's placed here is actually greater in the property at 1018 than it is in 1020. So I actually do, in a way, object to the front setback just by the fact that they're trying to bring this as close to the front line here, but certainly the side setbacks provide a reasonable encroachment on both the property 1020 as well as 1016 here.
So when
today
you
as well,
came
too.
before this board, you didn't ask for a side setback variance. You're 5 feet from the property line, is that, okay?
Correct.
All right, thank you.
My name is Jason Rarden. It's good to meet you all. I'm the other neighbor, and we'll just make this nice and easy. Basically echo everything he said, so that's all I need to say.
And did you ask for, or did your property get a variance from this board too, do you know?
I don't believe so. I'm actually not entirely sure, to be honest.
Okay.
And you don't object to the front setback
I
request?
not really, no.
Okay. Mr. Henry
Yeah,
again.
Mr. Chairman, members of the board, Sean Henry, 500 11th Avenue North. I think this could be really quick if the applicant would withdraw the application, the request for the side yard setback, you'd have unanimous approval here. But if they still want to get this variance for the side yard, we certainly don't believe, and you've got a letter from my partner, George Dean, this is not an exceptional lot. There's no exceptional narrowness here. It's 50 feet wide. That's the standard on Alice Street. Financial gain is not supposed to be the only basis by which these things are considered. Here, it seems like it may be the only basis. And then finally, no injury to neighboring property. You've got the two adjacent property owners here on either side of this who would be greatly impacted by a reduction from 5 feet to 3 feet next door to them. So we ask that you disapprove the request for the side yard variance and approve the front setback variance.
Okay, thank you. Any other questions? All right. Thank you. We will. All right, well, so we're going to be official about it, though, and we're going to let these folks go back and let the applicant come back and tell us. All right, based on what you've heard.
Absolutely. Yeah, I'd kind of actually originally, as a builder, had pushed the owner to remove the side setback. I've only been to a couple of these, and I was more as observant, and I kind of told him that would be the case. So I did express to the owner that.
So you're withdrawing the side setback request?
Yes, be happy to.
And did you have anything else to add?
No, sir.
Okay, we'll close the public hearing. Since that was consentable, I'll move that we approve the front setback variance to 33.95 feet as requested by the applicant. That motion is seconded. Is there any discussion? All in favor of that, say aye. Raise your hand. Any opposed? That is approved. Thank you.
All right, Mr. Chairman, that concludes your.
And with that, we are adjourned. Nothing else. Good.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.